Members, the committee is resumed on the Regulatory Standards Bill. We were considering the bill last night. We were debating Part 2. This is a debate on clauses 8 to 40, principles of responsible regulation and regulatory stewardship, and Schedule 2. Once again, the question is that Part 2 stand part.
Mr. Chair.
Honourable Dr. Duncan Webb.
Thank you, Mr. Chair, and good to be back here going through the most substantive clause of this bill, which is Clause 8, which sets out the Minister's views of what the principles of responsible regulation are. And when we finish up last night, I was talking about the rule of law clause, and we're just going to, at least I'm proposed to just go through this essentially in order. But as has been noted, the Minister, and certainly in committee, it was put to us that we don't need to worry about the silence of this clause in many respects because it's not exhaustive. But of course, if you have a list of principles, there's two things to say. If we have a list of principles of responsible regulation and something's not on it, it certainly puts that principle that's not on it in a kind of level of second-tier importance. And of course, the other thing is that in terms of the role of the Regulatory Standards Board, the Regulatory Standards Board actually can't look, when it's assessing regulatory quality, it can't look at principles that aren't there. It can't say there's another principle of good and responsible regulation and we think this bill fails on it, even though it's not one of the listed principles. So it's actually not helpful, the idea that it's a non-exhaustive list. And so on that, I come to my next amendment paper, one that was lodged at 9:45 on the 4th of November, which is how we'll be able to identify them, which amends Clause 8 and inserts a new clause which is probably, when you think about it, the most fundamental principle of lawmaking in New Zealand, and that is to say that the law of New Zealand, that good regulation should be consistent with our founding document. So that is, and this is a very important point, and it's one that deserves articulation by other members as well. I'm sure they have different perspectives on it, but from my perspective, if you think about the legitimacy of the government of New Zealand, the authority of the New Zealand government and Crown to govern all people in New Zealand, including Māori, it comes from the Treaty of Waitangi and the principles of the Treaty of Waitangi. And the Minister might want to put his own amendment paper in which doesn't use the word principles, because I know that there's a discussion around whether it should be is consistent with the treaty or is consistent with the principles, or he might want to say consistent with these principles, which are the principles of the Treaty of Waitangi, which is something else that he's tried to do here. But to say that there's this framework of good regulation, but to be entirely silent on the obligations that the Crown have regarding the manner in which they govern, including respecting tino rangatiratanga, including respecting the rights of Māori to self-determination, including the obligation to consult not just generally, but with Māori on things that affect Māori, to ensure that the treasures of Māori, the taonga in the Māori version, are preserved and protected, to ensure that in accordance with the principles of the Treaty of Waitangi, the Crown actively protects the interests of Māori. The bill says this is how we make good law, and it is 100% silent on how good lawmakers adhere with the most fundamental principles of our country, the very founding document. And I'm sure the Minister will respond to this, and it may be that my amendment paper is too simplistic. He would like to see it fleshed out somewhat, and I'd encourage him to do that. But silence on the treaty, or you might make it shorter, the law should take into account the Treaty of Waitangi. That would do. That would be a step in the right direction. But to be absolutely silent on it is to leave a gaping hole, which actually shows that this piece of legislation is not, makes no sense, can't be effective. Kia ora.
Mr. Chair.
Commander Ballich.
Thank you, Mr. Chair. I too want to focus on Clause 8, which is stated as the rule of law principle in this bill. And I was listening carefully to the Minister last night when he was talking about the reason that he decided to implement this bill, and he said, from his perspective, this was simple. And I thought about that, and I wanted to ask the Minister a few things around the particular provisions in this rule of law proposed law and this clause that he has proposed, because just by reading it and looking at it and analysing it last night, Mr. Chair, it appears that most of these particular aspects of the rule of law have not been ones that the Minister himself and his government have been able to follow in the way that they have enacted laws. And so just to be specific with references to the clauses, Clause 8A1, the law should be clear and accessible. Of course, this government has repealed the plain language bill, which was exactly for that purpose, making law clear and accessible. Clause 8A2, the law should not adversely affect rights and liberties or impose obligations retrospectively. Of course, we've seen the Pay Equity Bill and now Act go through taking away rights retrospectively from New Zealand women and changing the rights that they have under a retrospective law through urgency. 8A3, every person is equal before the law. We've seen particular legislation go through this House last week on the MACA law, which particularly targets the property rights of a particular section of the population, indicating that, in fact, under this government, every person is not equal before the law. Then we see 8A4, that there should be an independent, impartial judiciary. We have heard comments from the Minister's own Deputy Leader, the Minister for Workplace Relations, questioning the impartiality of existing Employment Relation Authority members and saying that the Employment Relations Authority members that she in fact appointed would be more likely to give a favourable decision in relation to employers. Now, I'm paraphrasing there, that's not a direct quote, but that is my recollection of what happened in that situation. 8A5, that issues of the legal right and liability should be resolved through the application of law rather than the exercise of administrative discretion. Mr. Chair, the fast-track legislation is an example of when you have an exercise of executive discretion in relation to the projects that are listed. So I want to ask the Minister, in this particular clause, would this clause have stopped those few examples that I have listed from being enacted? And if not, what is the point of this clause? And how can New Zealanders trust this government to uphold the rule of law when, just off the top of my head, it is so easy to find examples of where it appears that his definition of the rule of law, as he has put in this bill, has actually been broken?
Mr. Chair.
Dr. Lawrence Unan.
Thank you, Mr. Chair. I want to start today by discussing Clause 8A, so rule of law. Just to signal to the Chair as well that, each of these sections under the cross-heading deserves its own individual attention, but I'm going to focus on the rule of law first. I think in terms of what the Minister has put to the Minister, in terms of what we see here in the rule of law, a lot of them, prima facie makes a lot of sense, but I want to pick up on a few points here. And the first one is around every person is equal before the law. Now, the idea of rule of law, of course, goes back, for a while. But what we're seeing now is that the expectation and reality are quite different in terms of everyone being equal under the law. Because, for example, different people have different ability to pay lawyers. That is not equal. The other example is, as we see with the most recent sentencing amendment bill, that if you have more money or you can pay for reparation, that you can go above the 40% cap in terms of the discount for sentencing, which is also technically not everyone being equal under the law, because everyone have different ability to pay. So if we're looking at something where every person is equal before the law, then would the minister then, for example, consider that there be a cap to anything that is in front of the law, or that access to law should just be free for everyone, in which case everyone then would be equal and have free access to that. And in that sense, I would agree that yes, everyone is equal under the law. So I guess my first question to the minister is, how does the minister reconcile the fact that the equality before the law is an ideal but not a reality? And how would then the minister hoping to address that reality through this particular section and through this particular legislation? The second question I have on the rule of law is there should be an independent, impartial judiciary. And I agree with that. Anyone has ever done any law would, know about separation of power and about the principle of comity. But I wondered we have seen in many ways judiciary do their thing. They make rulings, they make judgments, they make interpretations, and it is rightfully judiciary to do. Judges has not come out publicly to criticize governments, to criticize ministers, to criticize the legislature nor the executive. They interpret the law through legislation. However, we have seen executive and legislature come out openly criticizing the judiciary, which violates the principle of comity. So I want to get the minister's advice and opinion on that. If there should be an independent, impartial judiciary, how then do we also account for, I guess in some ways, the lack of impartial executive? And I know that a lot of this part of this bill focuses on, and rightfully, about the executive overreach in certain things. And we want to have the ability for the legislature to be able to scrutinize the executive more, and also the ability for judiciary to scrutinize the executive more, which means conversely, what then are we going to be doing about a lack of independent or independent, yes, but particularly impartial executive? So those are my two questions, is how then will the minister address or consider or have thoughts on the lack of equity or equality before the law currently, particularly around how much people are able to pay before the law or before a judge, and using the example of the sentencing amendment bill, and also in terms of the issue of impartial executive in some of the things we have seen.
Mr. Chair.
Timothy Paul.
Thanks, Mr. Chair, and my questions are also in the section relating to the rule of law, but from a slightly different angle. So every person is equal before the law, and we traversed the meaning of the word equal or equality in the Treaty Principles Bill discussion, but I want to bring it back today because obviously there are different ways to interpret the word equal. There is formal equality, which is the concept that everybody gets the same thing. And then there is substantive equality, which is the recognition that everybody doesn't start out on the same playing field, and that because of that, some people need more than others to bring everybody up to the same level. So what does the minister mean when he says equal before the law? There's probably more interpretations to the word equal than those two. Dr. Marilyn Waring had a really good explanation behind those two concepts, but what do you mean by equal? Because there's lots of different ways to interpret that one word. And I think my colleague, Dr. Zunan, touched on some really good examples of inequality before the law, because this sentence, every person is equal before the law, is simply not true in our courts and the way that our law is applied. So Dr. Zunan made some really good points around how much access you have to money can sometimes determine the way in which you are impacted by the law, which is a really great point. It made me think about even things like the removal of Section 27 reports, which allow for the courts and the judiciary to have a more fulsome understanding of who a person is, where they've come from, what their challenges are in terms of their health, their upbringings, etc., etc. But if you can't afford to commission your own cultural report now, you don't have the same standing in front of the courts. Unlike if you have money, you're able to access or commission those reports, and the judiciary will have a better understanding of who you are and will be more forgiving and more compassionate towards your circumstances, and will likely give you a more flexible or compassionate sentence because you have been able to pay for that report. So everyone isn't equal under the law. It depends on how much money you have access to. So can you address those discrepancies? But let's also talk about race when it comes to everybody coming before the law, because here's another fact for you, Minister. Māori are 11 times more likely to be prosecuted for the same offence as non-Māori. So I'd love if the Minister could explain where that discrepancy comes from, because clearly if you have a brown face and you appear before a judge or a lawyer, you are not going to be treated in the same way as somebody who appears before a judge with a white face. And that might be uncomfortable to hear, but that is the truth, and it has been traversed by many courts, many judges and many lawyers who point out the institutional racism that exists within our criminal justice system. So in terms of the rule of law, I'd love for the Minister to answer some of those questions, but it's the kind of obvious glaring omission in this entire section around the rule of law is the complete absence of tikanga Māori. The original law of this land, by the way, there is no provisions whatsoever that recognises tikanga Māori, despite the fact that many rulings in the court have considered and applied tikanga Māori. And if we want to be specific about what that is the original law of this land and the way that decisions and justice was fulfilled for the Indigenous people who are here in this country first. And in this modern day, in 2025, it's not extraordinary or spectacular to see tikanga Māori to be written into and considered into a judgment. So why is it that in this piece of legislation that attempts to be a modern piece of legislation completely ignores the very hard work of people like Justice Joe Williams, who have incorporated tikanga into their rulings? This completely erases that and makes no mention whatsoever of tikanga Māori, which is why I've drafted an amendment paper to amend this part to include the importance of maintaining consistency with the following aspects of the rule of law, noting that nothing below precludes tikanga Māori being recognised as the original law of this land. So I'd love it if the Minister could start there, but I've got more questions around te tiriti and tikanga Māori to follow.
Thank you, Mr. Chair, and I also have questions in regards to Clause 8 of the bill. I indicated to the Minister earlier during this committee stage that I had questions around the genesis of the principles chosen as compared to the rights that we have expressed in the Bill of Rights Act. And the point I'm making is that there are, when you're setting something up as being aligned to the rule of law in terms of something that we should consider constitutional, what we've done in the past is we've developed rights that are based on international law, and the Bill of Rights Act is an example of that, drawing from the International Covenant on Civil and Political Rights. So that's one element of legitimacy, if you like. And the other limb of legitimacy is that it's well socialised with the people of New Zealand, and the example I used was the same, that the Bora in its day was socialised with the people of New Zealand through two political campaigns, and and there was much discussion and deliberation across the House in terms of firming up those principles as rights in New Zealand. So the first question is really, where is the genesis for the principles, particularly around the taking of property and the principles there that the Minister is drawing from, and how does that relate to that history of drawing from international law, so covenants as opposed to declarations. Covenants, of course, have direct obligations on nation states, but also the socialising with people to ensure that it is truly a norm, particularly in light of the massive opposition that we all heard, not only in the Select Committee room, but also on the streets of New Zealand across the country in relation to this bill. In many respects, it feels like the opposite of evidence is available that demonstrates that the people of New Zealand do not want this to be a principle that is one which other pieces of legislation and regulation are marked against. The other point I would make is, the other question I would have for the Minister is where he considers these principles to sit in terms of their ranking against the Bill of Rights Act rights. In the first part of the reading, the Minister, I thought very helpfully, indicated in response to Dr. Webb's proposal that certain things should be excluded from this analysis, including the Bill of Rights Act and the Constitution Act. The Minister said that Dr. Webb could be correct, but it's very likely that those acts wouldn't be found to be in breach of these set of principles anyway. So my first question there is his view not that we should be clear in the law about what's included and what's excluded, and the statement about the fact that Dr. Webb could be correct, to my mind, is an indication that maybe an amendment is needed across this bill to make that very clear, given that we're talking about constitutional law as well. But the second part to that is, in which case do the rights in the Bill of Rights Act take precedence? I note here also that the Minister has chosen not to include clauses that we do have in the Bill of Rights Act, section 6 and 5, which are the engagement clauses. Those are in many ways the heart of the Bill of Rights Act, because they direct decision makers to turn their minds to consistency, but also reasonable limitations on rights. So that's the active part of the Bill of Rights Act, in my view. The Minister's chosen not to do that in this bill, which says to me that clearly the rights in the Bill of Rights Act take precedence. And although Section 4 of the Bill of Rights Act would point to other legislation if there were an inconsistency, and this bill would seem to point back to the Bill of Rights Act, my view on the read of the two is that the Bill of Rights Act would take priority when the two were pointing at each other in terms of an inconsistency. So it would be useful to have the Minister's view on which takes precedence.
Mr. Chair. Thank you, Mr. Chair, and thank you, members, for your questions and comments. Duncan Webb said that the Regulatory Standards Board cannot consider principles under 8A. The Regulatory Standards Board would be considering the consistency of a consistency accountability statement if a member or a minister bringing a piece of legislation chose to consider those, then I don't see why the Regulatory Standards Board couldn't consider it. He went on to say that he has an amendment paper to insert a Treaty of Waitangi clause. The government has no intention of doing that. The Bill of Rights, the Constitution Acts, a number of important acts do not have treaty clauses. And there's also a practical reason for that, that if you look at the principles in Section 8, they're all quite practical. They set out what a person can expect from the law in quite specific terms. If you had a treaty clause, then it would open up a new debate about what that means, which members have already alluded to. So we have no intention of supporting amendments to expand the principles, and I note that standing orders and speakers' rulings are very clear that there's a limit to the extent that members can try to extend a debate by talking about what's not in the bill or hypothetically could be in the bill. Camilla Bellich argued that... I'm sorry?
Let's not have cross
I couldn't quite understand that, but Camilla Balich argued that the government hasn't followed the rule of law, and I, in my view, made a series of political attacks on the government. But if she's right to lament that the government has not followed the rule of law, let's just imagine for a moment that she was, then of course she should welcome this initiative to put these rule of law principles in statute. In fact, she seemed quite eager for that, because she asked, would the statute stop the government passing a law? I've been quite clear in part 1, and if you look at section 25 of this part, that the bill does not prevent Parliament passing a law. It does require the executive to be more accountable and transparent with Parliament, so it might mean that people were less willing to commit the various crimes that Camilla Balich accuses them of if there was more transparency. Lawrence Yunnan and Tamitha Paul both raised a series of issues around the practical ability to access the law in their critique of the rule of law section, particularly the idea that every person is equal before the law. There are extensive political debates about equality of opportunity and equality of outcome. There are policies, for example, legal aid that assist people to access the law. There has been in the past funding for Section 27 reports. Those are all interesting and important areas of policy debate, but they actually don't concern us here. The statement every person is equal before the law simply means that if there is adjudication of a matter, then people should not be treated differently based on their identity in the same circumstances. Very happy to have a debate about access to law and legal aid and so on. In another format, but it's not actually relevant to this part, Venushi Walters raised questions about the role of international law. She raised questions about the Bill of Rights Act. Is there precedence over the Bill of Rights Act by this law, given that there might be, in theory, a review of the Bill of Rights against these principles? As I've already stated in part 1, I don't believe that would lead to a conflict. I don't believe that these laws are in competition. So we're not intending to make any change in that area. There also was, I think, questions about international law. I think we've got to be clear that signing a treaty with another foreign government, for example, that is an initiative that a government might wish to take. It might wish to bring confirmation legislation to the House. The purpose of this legislation is simply to make sure that the impacts on New Zealanders of any government initiative, including interacting with foreign governments, is clear to Parliament and clear to the people who send us to this Parliament. It's not necessary to then put the driving force behind such an initiative in this bill. I hope that helps members with their questions.
Honourable Dr Duncan Webb.
Mr Chair, and obviously this Clause 8 is the absolute workhorse of this bill, and discussion as to how it might be improved is not really talking about what isn't in the bill. It's actually talking about the very bricks and mortar of this bill. And my amendment paper that was lodged at 9:45 on the 4th of November, I see there's two in 3 seconds, because the next one's at 4 seconds. Talks about, rather than sort of just alluding to the rule of law, actually alluding to something which has echoes with the New Zealand Bill of Rights Act, and that is that the law should reflect the fundamental values and principles of a democratic society. And again, some of these suggestions have been drawn from the Legislation Design and Advisory Committee guidelines, and that is one of the guidelines, or one of the principles in the LDAC guidelines. And I do think that it's a better touchstone in some ways than the rule of law principle, because it really just does talk about what, it gives a more expansive view of what a free and democratic society is. But I wanted to touch on that briefly, but the one I really wanted to talk about a bit more was an amendment paper which talks about Parliament and the role of Parliament as opposed to delegates, because one of the really important aspects of good lawmaking is to make sure that this House is the preeminent lawmaker. And whilst it's busy and it keeps us, pretty well occupied, we've got to be very cautious about over-delegation. And one of the dangers is that we give to other entities, whether it be ministers or government agencies or even non-government agencies, as is discussed later in this bill, we've got to be cautious that we don't accord them too much power. So my amendment paper at 9:45 on the 4th of November and 5 seconds says that it just identifies the principle that legislative power resides in Parliament, and delegation of legislative power should occur only when it's necessary to achieve a policy objective, it's subject to appropriate oversight, and provided that it is limited to legislating to implement policy and empowering legislation. That is to say, it's really important, and this goes to the arbitrary power point, and I know arbitrary power and of course too many regulations is one of the things that's dear to the heart of the Minister, but that whole idea of limiting legislation to implementing policy rather than making policy. And whilst it's a vague line, and this is sometimes called a Henry VIII problem, but whilst it's a vague line, it is a meaningful distinction to make sure that we don't give ministers, importantly ministers, but especially bureaucrats, people who aren't elected, the power to make substantive legal change about the rights or entitlements or duties of citizens, because that's actually at the heart, and that is at the heart of our democracy, that we elect people to this place to make laws which change rights and entitlements, and whilst an exemption power for a licensing regime might sit with a senior person in the Ministry of Transport, what shouldn't be there is what that licence looks like and what it entitles someone to do. So I do think we need to be cautious about that. Whilst there is a huge amount of regulation, and it is appropriate that some of it is delegated, I think it's an important principle of good lawmaking that substantive policy decisions which allocate rights and burdens and benefits and those sorts of things actually sit with this House, and that's why I put that amendment paper in for Clause 8.
Dr. Lawrence-Zunan.
Thank you, Mr. Chair. I want to follow up what the previous speaker, the Honourable Dr. Duncan Webb, but actually I want to move on from the rule of law and talk about a separate section in terms of the liberties part of this, because again, this is the substantial section in terms of the principles, and I think each cross-heading deserves its own attention. But just before I start on the liberties, I want to check with the chair, and just a point of clarification, that the minister before did say that happy to have a debate on access to justice, and I wondered, if the chair is allowing that to be a green light for a broader discussion on access to justice in relation to everyone is equal before the law.
I'll let you continue your discussion. I'll take some advice while you're doing that.
Cool. I will start with the liberty section, and then we can move back depending on the chair's ruling. Note that it is the chair who rules on standing orders and speaker's rulings. And in terms of the liberties, I agree that when we're looking at something like this, again on the surface is reasonably it is logical, but I think I would like to sort of peel away the kind of the veneer of this particular section and look at specific wordings within this. I guess the question here is, if we're looking at the original idea of freedom of choice of action, if you're going back to let's say 5th century BC, when we're in front of the Agora and talking about the, Isagoria, which is the origin of the freedom of expression in vis-a-vis the freedom of debate in the marketplace. It was very clear back then, and this is where we get our current idea of freedom of expression from, that the idea of freedom of expression does not equal to freedom of consequences. Very clearly in the 5th century, if you're looking at 480 BC, when at the forum, everyone has the right to debate, and everyone have the right to contribute to a discussion. And a particular man in the Athenian Forum back then did say that, hey, we are facing a Persian invasion. Why not we just surrender to the Persians? It was absolutely within his right to express that as freedom of expression. However, it didn't stop him from from there to be wide outrage in the Athenian Forum and for him to be drawn and quartered. So the idea there is, and I think the moral lesson over there is that freedom of choice and freedom of actions does not equal a freedom from consequences. So when we are looking at the liberties and freedom of choice of action, I really want to get the minister's advice on how does this, and the minister has referenced Human Rights Act and and NZBOR as other key sort of constitutional document here in Aotearoa. How then does the minister balance the two of freedom of expression and freedom of consequences? Because again, like the minister is suggesting through here in terms of liberties, that people have the right to express certain things. We've seen that in the most recent Education and Training Amendment Bill in terms of freedom of expression at universities. However, what happens then if those words or choices then harms other people, either through NZBOR or through the Human Rights Act? Would that still be allowed within this particular legislation, or within the drafting of or within the approval or CAS of a particular bill? Because it does open up broader questions then. Or alternatively, if we're looking at freedom of choice or action, how does that reconcile with, let's say, the Crimes Act? Could then, with any piece of legislation, or if this is a core tenet that people can base things on as something that is of a constitutional nature, could that one say, I have the freedom of action to assault someone? Does that actually mean that, when you are making verbal threats, which we all agree in this house that verbal threats are illegal, and, many of those kind of things, verbal threats, are already covered in the Crimes Act, are those considered in freedom of expression, or would that be captured under, rightfully under the Crimes Act? And so this is kind of, I guess, my big question to the minister under the liberties section, which is how then do we balance that, I guess, a social contract within our society, and that, that kind of carte blanche freedom of expression or action. And I'm also waiting to hear feedback and advice from the chair regarding my other question.
Just to clarify for the House, I just clarified with the Minister as well, it wasn't an invitation from the Minister to debate that stuff right here, right now, but it's in another forum. So a broader debate can happen outside of these chambers if people want to organise that. However, the green light is for people to focus on the clauses and the sections. There is quite a bit there. I know this is a substantial part, and so if members could keep their comments to that would be very helpful for the House. Venushi Walters.
Thank you, Mr. Chair. I wanted to ask the Minister a question about his drafting choice in terms of looking at what I would call simple incompatibility with his principles versus a potential drafting choice he could have made for justified incompatibility. And I referenced this in my previous question, but I don't believe that the Minister has responded. So I referenced Section 6 and 5 of the Bill of Rights Act, as well as Section 4, and I called it the heart of engagement with the Bill of Rights Act, because that's really where decision makers do engage. It must be read compatibly. You can have justified limitations. If that's not possible, then the other piece of legislation takes priority. Now, the Minister's made a drafting choice in regards to this bill not to include those engagement provisions, and I really am curious as to why. I just note that Dean Knight made this observation in some of his commentary, and I believe in his submission as well, and suggested that there would be cases when you could have justifiable limitations or justifiable incompatibility or justifiable limitations. He also suggested some specific drafting in terms of Clause 8, which I will read out because I do think it's very helpful, and I think it's an important question in terms of understanding why the Minister hasn't made this choice. So he's suggested that in Principle 8 it could read, the principles of responsible regulation are except as provided in subsection 2 as follows. Subsection 2, he'd suggest, then could read, any incompatibility with the principles is justified to the extent that it is reasonably and can be demonstrably justified in a free and democratic society. So it uses similar language to the language that we do have in the Bill of Rights Act. And again, a question here about whether the Minister considered this in terms of turning decision makers' minds directly to not only compliance or not, but that middle ground, which is where could you justifiably limit these principles, which I think is certainly part of our history in terms of encouraging decision makers to engage with constitutional principles, which essentially these purport to be. The other question I had for the Minister was around Clause 8, the section that relates to the role of the courts. Dr. Duncan Webb has some very useful proposed amendments here that I'll refer to in a moment, but the current clause reads, legislation should preserve the court's constitutional role of ascertaining the meaning of legislation. And by using the word of, the provision implies that the court's only role is to interpret Parliament's legislation, and that's simply not true. That's a fabrication. In fact, as long ago as 1972, the well-respected judge of the Judicial Committee of the House of Lords, Lord Reid, said that the idea that judges do not make law is a fairy tale. Yet I raise it here partially because of the way that the bill is worded, but also because we've seen several instances of government ministers of late stepping into this space and claiming that there is judicial overreach. My view is that it's a misunderstanding of the nature of the role of the judiciary, which isn't just to interpret the law, it is also to develop the common law. And as the Minister would know from the last term in Parliament and the insertion of the Declaration of Inconsistency clauses into the now updated Bill of Rights Act and into our standing orders, it's also the role of the judiciary to hold this House to account, to return things to the House, to ensure that we look at them twice. Now, Dr. Webb's proposed amendments, this one was submitted on the 4th of November at 9:20 a.m, proposes an amendment to Clause A and replaces that flawed wording with, I think, much more sensible wording that sets out in truth what the role of the courts are. So I'd appreciate the Minister's comment about the proposed amendment.
Do you know what time or date that was? Because there's a lot that came in at 9:20.
9:20 and 5 seconds.
Mr. Chair.
Mr.
Chair. Thank you, Mr. Chair. Just in response to the last three speeches, Duncan Webb suggested that Parliament should pass a law asserting that it is the supreme lawmaker in the land. That would be to produce a piece of legislation that people could dispute. And there's an old saying, I think it was Margaret Thatcher said, if you have to say you're a lady, you're not. And so it would be very unwise for Parliament to make that statement and actually call into question its sovereignty as the only lawmaker. Duncan Webb then went on to talk about, I think, Section G, the idea that, or he talked about delegation, that there shouldn't be too much delegation of other rules. Well, actually, I think Section G, which Venushi Walters also mentioned, is quite helpful, and that it says ultimately it's the court's role to ascertain the meaning of legislation. It shouldn't be somebody in the bureaucracy making random calls. So I think that actually helps address his concern. Venushi Walters had a reading of G, the role of courts, that could be it could be interpreted as legislation should preserve the court's unique or exclusive constitutional role of ascertaining the meaning of legislation. We could have said that, but we didn't. We are saying that the legislation should preserve the court's constitutional role. We don't comment on what other roles they have or preclude them from having other roles, so the government's quite comfortable with Section G as it reads and would not like to adopt any other amendments on that section. Lawrence Yunnan, I've got to say I really enjoy his speeches, but they don't have a huge amount to do with the legislation in front of us. Certainly the Peloponnesian War is very interesting, but I thought his interpretation of free speech has consequences, and you might be hung, drawn and quartered for what you say. I mean, most of us on this side of the House would say the point of free speech is you can say what you like without being hung, drawn and quartered, but that again is a debate for another time. The relevant thing for Mr Hunan is Section B sets out, and he didn't really get into it, but I'll help, that legislation should not unduly diminish a person's liberty, personal security, freedom or choice of action or rights to own, use or dispose of property, except as is necessary to provide for or protect any such liberty, freedom, right of another person. So, for example, you could have noise restrictions perfectly consistent with these liberties. Does it diminish your ability to make noise after a certain time? Yes, but doing so also protects your peace and quiet after a certain time. In other words, the obligations are reciprocal and the benefits are mutual, and that argument could be extended to free speech or any other law that curtails liberty that gives reciprocal obligations and mutual benefit. So I hope that Vanushi Walters also raised the question of should we have drafted something like Section 5 of the Bill of Rights Act that says there are justified, I think she used a good term, justified incompatibility versus simple incompatibility. Yes, we have thought about that, but I'd draw her to Section 11B, which says that a minister can actually issue a statement explaining why a law has not been made consistent with these principles, and it's up to the Parliament and the public to judge them on that.
Before I take the next call, just to note that members are moving through the clauses and moving forward, so that is appreciated, and I would encourage members not to repeat previous sections as well. So I'm not looking for closure motions at this particular time, if that's what's been asked for. Yeah? Cameron Luxon.
Chair, it's not a closure motion. In the words of Lawrence Hunan, each part of the principles deserves proper attention, and I'm hoping that's what we're doing, Mr Chair. And I'd like to move to the taxes, fees and levies section, Section D, 8, D and E. It talks about authorising imposition of a fee for a good or service only as the fee bears proper relation to the cost. Just how would that function, do you think, Minister? And also, moving into F, we've got the tax, fee or levy that benefits the class of payers is likely to derive all the risks attributed to the class in connection with the objectives and functions and the cost of efficiently achieving the objective or providing that function. How are groups defined in that role? Like how are the people who are benefiting mutually or not in this case, how is that defined, and how is proper relation to the cost being imposed defined? Thank you.
Dr. Duncan Webb.
Thank you, Mr Chair. Firstly, just on the liberty clause, and there's an amendment paper of mine lodged 8:30:23 a.m. And really just noting that the framing of liberty, I think the framing of liberty in this bill actually comes straight out of John Stuart Mill's On Liberty, in that it says the only constraint on liberty should be something to preserve someone else's liberty. And that does what the ACT Party does, which is break everything down into individuals. And the fact of the matter is that there might be values about the wider society generally, which isn't so much about that person's liberty to go out their business, but about building a strong and good society, which is reasonable to place limits on someone else's liberty. So that's why my suggestion in that amendment paper, I'm just going to be very brief with this one, was that rather than saying legislation should place constraints on a person's liberty only to protect someone else's liberty, it should be only when it can be demonstrably justified in a free and democratic society, which captures the kind of liberty, freedom point, but also the wider democratic issues. What I actually wanted to do, though, and I do appreciate the guidance of the Chair, I want to move along to the takings clause, what might be called the taking clause, clause 8, subclause 8C. Now, in my amendment paper 8:30:24 a.m., I suggest that the whole clause be deleted because it's fundamentally not workable. Whilst, and it's well accepted the whole idea of no confiscation without compensation is a thing, right? And it is a part of the rule of law that you just don't take people's stuff, I think was the Minister's words last night. I agree with that, but we don't need that principle here. It's not kind of a critical principle of good regulatory quality. It can fall off the end along with things like the Treaty of Waitangi and international obligations and human rights. One of the problems is the way it's framed with this severe impairment. It's actually quite obscure because impairment of, and I know it's select committee and the Minister I know was consulted as to the select committee's view on this. The select committee took it from being just any impairment to a severe impairment to make sure we didn't have just trivial matters kind of clogging up the wheels of lawmaking. But the idea of impairment is difficult because an impairment can be simply through regulation, and the Minister for Agriculture will be a good example of that. The impairment of when you might have had a right to take water, but to preserve that waterway, that's limited. You might have had a right to discharge into a waterway, but that right is now going to be limited. Now, that's not taking property, but it would suffer, it would fall within the impairment principle because it's changing a property right in a way which gives a less extensive ability to use that property. And that's a very difficult area. Now, if the Minister wasn't minded to accept that, I'd suggest he accept my other paper, which was lodged at 8:30:25 a.m., which actually just replaces it with a much broader framing of the taking principle, which is, sure, legislation shouldn't take or authorise the taking of property. So that's a genuine taking rule, which is actually the American view, the American framing, without the consent of the owner unless there's good justification, fair compensation, and the compensation is provided by on behalf of the persons who benefit the taking. It's actually using a much more workable framing and one which has good jurisprudence in the United States. And if you look at the explanatory note there, you'll see I've cited Lucas and South Carolina Coastal Commission, which talks about what that framing, the taking framing, what amounts to a taking, because taking's a lot clearer concept than impairment, and it actually accords much more closely with the framing of our law in New Zealand. So 2 amendment papers, one, do away with it. The other one is, look, if you're going to use it in a way which is familiar around the world already and is in fact based on the United States Constitution approach.
Mr. Chair.
Francesco Hernandez.
Take my first call of the morning, and good morning to all the members and the Minister and the Chair. I wanted to also talk about C, which is the taking of the property clause, and ask about its interaction with the taxes, fees and levy clause that subsequently follow. The fact that they're different kind of tells me that there's a difference that the Minister views between a tax and taking of property, for example, but as per the previous member's contribution, why not just kind of merge the 2 clauses together? And I wanted to ask about what the threshold was that the Minister considers for severely impair versus merely impair. Are there any case law or examples he can give on what the difference of those 2 might be? And I want to move to the other parts of this clause as well, around the good justification. Is that defined somewhere in the Act, along with the fair compensation for the taking and the compensation provided as well? So just taking a very short call to ask about this section. I'll have some other calls as the principles develop, but thank you for the engagement so far.
Mr. Chair.
Chairman Luxon.
Thank you, Mr. Chair. Yes, in the spirit of the Speaker who's just sat down, I'd also like to move to the good lawmaking clause, and specifically the importance of carefully evaluating the issue concerned and how that interacts with the effectiveness of any relevant existing legislation and common law, as in what, if there is an issue concerned, are there already laws with it? Is that going to the review and new laws? Whether the public interest requires the issue be addressed, how does that work? Is it saying, like, look, this is maybe a storm in a teacup or some such? How would that function? Any other options? I guess that feeds into 8J which I've just talked about, and 4. And also, the key part, I think, is who is likely to benefit and who is likely to suffer a detriment from the legislation. It'd be interesting to hear how that would actually be communicated. So if you could speak to those, Minister, that'd be helpful. The importance of the responsible agency identifying and developing effective arrangements. Again, the questions came up in part 1 about the responsible agency, but also that just clarifying which agency. I know it's in the definitions, but maybe this could be better clarified for the committee. Thank you.
Venetia Walters.
Thank you, Mr. Chair. I am also looking at the good law making clause. My first question is around the language that refers to consultation and the importance of consulting to the extent that it is reasonably practicable, the personal representative of the persons that the responsible agency considers will be directly and materially affected by the legislation. So the first question is to what extent the Minister envisages that this part applies to our parliamentary process. So are we talking about consultation in the early stages of the development of law, or are we also talking about the parliamentary process? The reason I think it's important, Minister, for the Minister, is that it refers to people who are directly and materially affected by the legislation. But of course, in terms of the parliamentary process, everyone in New Zealand has the ability and the right to submit their views to Parliament, whether they're materially directly affected or not, whether they simply want to comment as part of that process. So my view is that this clause would sit separately from what we understand to be good parliamentary process, but it would be useful to have the Minister comment on that. The second question is if it does apply more broadly to our parliamentary process as well, what he understands the reasonably practicable threshold to be and how that would operate. The examples we see in the House at present, I found Camilla Bellich's examples earlier really useful, just in terms of making this kind of theory-based bill, giving it some flesh and bones in terms of what it would mean. The example I'm thinking of is we have a bill travelling through the House that would allow people to be automatically exempted from jury duty, but at a higher threshold than they currently are. That's gone out for consultation. We've been talking to people, hearing their views. We've also had this year changes to pay equity legislation, which did not go through that process. And so if this was a bill that applied equally to our parliamentary processes, would that fall afoul of what the Minister would believe would be reasonably practicable or not, is my second question. And then I look towards the end of that part that outlines what is good lawmaking, and was just noting an absence, which is the function of either the duration of the law itself. The Minister will be aware that from time to time there are sunset clauses or provisions within bills that require a review, or reference to reviewing legislation or identifying when active post-legislative scrutiny should occur. Of course, there is now the new subsection 8A, which says that other principles, standards or guidelines not limited or affected are not limited or affected, which I do think is useful. However, again, it is a drafting choice not to include a reference to review, sunset clauses, post-legislative scrutiny, and I wonder why the Minister had made that choice. Thank you.
Mr. Chair, Thank you, Mr Chair. Thank you for those good questions from Venushi Walters. Can I just start with the question by Cameron Luxon about sections 8D, E and F around taxes, fees and levies. The basic purpose of this is to reinforce a principle that in theory governments should already be following, that if they raise a fee, you should get what you pay for and you shouldn't pay for more than what you get. Cameron Luxon asked who might be a group that would benefit. I'll give you one example. The government recently considered the fees that are levied on abattoirs to fund vets who then go and inspect the abattoir to check that the meat is being prepared in a hygienic way so it won't create reputational risk to New Zealand. The group in that case is primarily those in the meat industry who are paying the fee. They also get the benefit, and then there's a question of, well, what is the true cost of doing this and is it fair? The government scrutinised a whole lot of that, whereas we wouldn't want to have a fee that was being used, levied on one group of people, then used to fund somebody else that didn't actually benefit that group directly. That should be done under general taxation, which I'll just come back to something that I think it was Francisco Hernandez said, why not merge the takings clause, sections C, with taxes, fees and levies. Yes, a tax is different. In our tradition, there is fiscal policy where the Parliament votes to levy taxes and usually garnishes a percentage of somebody's transaction, whether it's earning income, buying something, owning property, some would suggest. And that is quite different from actually taking property directly rather than taking some portion of money. So they are different things. We have no intention of merging the two. And then there was a question from Duncan Webb about having effectively the same thing as Venushi Walters has mentioned, but in relation to 8B, liberties, there should be a clause, an out clause, if you like Section 5 in the Bill of Rights. I've already said that we don't wish to do that. There is a mechanism in 11B that does that. So that's been addressed. The government has no intention of adopting that amendment. And then he also said, that I think that was the end of that. If I've missed anything, I apologise. Pardon? Oh, the takings clause, yes. He said, why not remove impairment and have only takings? I guess the question is, what is the difference between taking someone's property and introducing a rule that reduces its value by a quarter or a half or 3/4? In my view, if a regulation deprives someone of the use and enjoyment and value of their property, then the percentage it takes is not really the point. If you want to put an SNA on someone's land, for example, that reduces the value of their property and their use of it, if the whole society wants to do that, then rather than putting the cost on the one poor person who happens to own that piece of land at the time, we should fund that collectively because it's a collective enterprise, even if it doesn't take all of their property. So there's a purpose to this. It's been well thought out, well traversed, and we have no intention of changing that. Then we had Cameron Luxon ask another question about good lawmaking. These are the sections from I to L, Indigo to Lima. These are a series of questions that are comparable to what in theory governments do with a regulatory impact statement. Show that consultation has been done. That's I think that's fairly self-explanatory that you should try and consult the people who are concerned. Venushi Walters raised a question about that where she said, isn't that undermining Parliament, where Parliament everyone has a right to submit to Parliament? I agree with her about that, but if you go back to the purpose statement of the law, which we traversed in part 1 yesterday, this is designed to improve the quality of lawmaking by furnishing consistency accountability statements. So it's for the purpose of those consistency accountability statements, not all of Parliament's lawmaking, that we are doing this. We go on to the importance of carefully evaluating the issue concerned, so actually defining what problem we're trying to solve. Again, problem definition is I would argue not done very well, and some of my recent reports as Minister of Regulation, frankly, frankly, have shown that, and the effectiveness of other alternatives. Are there other things that could be doing? We should have option analysis, whether the public interest requires the issue to be addressed. Why are we actually doing this? Again, you have to have a good problem definition. Any other options that are reasonably available? Sometimes self-regulation is an option. We should put all the options on the table before we go to the big hammer of using the law to restrict people's rights to use and exchange their property. And who is likely to benefit and who's likely to suffer? Often people want to know, Mr. Chair, who is this for? That is a very important thing that, again, the public should be able to see. If the government's making a regulation, then cui bono? I'm sure some of the learned people on the other side will want to ask the question, who benefits? Finally, implementation. This is something added by the Select Committee, and I welcome this suggestion because if you don't know how you're going to implement it, laws can go badly. I would say the Resource Management Act is a good example of that. The implementation in the early 90s was never done as intended, and I believe that has caused huge problems and costs for New Zealanders. Benefits should exceed the costs. You know, at a societal level, making this law should actually make us wealthier overall, and by wealth I don't just mean money, I mean general benefits that people might derive and enjoy. But you should at least be able to say to the public, this is why we think overall New Zealand will be better off with this law. If you can't do that, maybe you shouldn't make the law, and it should be the most effective, efficient and proportionate response to the issue as concerned. So once we've gone through all of that, we've defined the problem, we've analysed the options, we've weighed up the costs and benefits, we've identified the winners and losers from the law, we should also be able to say we didn't do any more than we had to given all of that analysis. So that is good lawmaking. I think it's a very important part of the legislation. And then Venushi Walters asked about limits on parliamentary process. Oh, and she also asked, is it early or late in the process? Again, go back to the purpose. This is to furnish consistency accountability statements. It's not necessarily putting any restrictions on people earlier in the process, but if you were a minister making a law, then of course it would be smart to start early in defining your problem and doing your analysis and weighing up your costs and benefits so that when you come through to publish a consistency accountability statement on passing a secondary legislation or introducing legislation to the House, then you've done your work and you can show that your law makes sense in line with these principles. So that would be the smart thing for ministers to do, and I'm sure the government will be issuing internal guidance to do that. And that is, well, Section 27 requires the issuing of guidance. We can talk about that too if the member would like to, but I've addressed, I think, all the questions to date.
Dr. Lawrence Unan.
Thank you, Mr. Chair, and I really appreciate the Minister responding to my previous questions. Now, I just want to kind of tie up a few things on the principle section because, you know, we've have spent a little bit of time on this and we're happy to move on soon to the subsequent clauses. But I want to just touch on a few of the last things that various speakers has also mentioned but haven't actually mentioned in a specific way. First of all, I think, you know, in terms of taking off properties, you know, it talks about good justification and impairment, and I think that was touched on before. But I want to focus on the idea of owner. I want to draw the Chair's attention, the Minister's attention to my colleague Francisco Hernandez's amendment paper, which is specifying that for the purpose of Clause 8, C, Roman numeral 2, that the owner means an individual only and excludes any private company. And the reason for that is because I see where the minister is coming from in terms of this idea of taking off property, but I feel like if we're expanding it to companies as well, that actually is countering to what we're trying to do here, because companies, although it's defined as owner or person, you know, a legal person under legislation, it's not, my understanding is it's not what the minister is trying to aim for in this instance. And, you know, if the minister is like, actually, you know what, when I say owner, I meant private and not corporate, then, you know, that clarification is sufficient and we can just ignore the amendment. In terms of the tax fees and levies portion, now I'm reading this part, in particular, I'm looking at E and F Roman numeral 1 when it talks about, you know, goods and services, if the amount of the fee bears a proper relation to the cost of providing the goods and service, and also, if the levy is reasonable in relation to to the benefit that the class of payers is likely to derive. I want to check, because that sounds like that under this legislation that a capital gains tax, for example, is reasonably appropriate, because you're looking at, in one way, you're looking at tax fees or levies that is reasonable and proportional to the benefit that the class of payers is likely to derive. So something like a wealth tax, I feel like, would be considered. This is part of the bill. If you have a question, please make a contribution as well. But the thing is, what we're doing here is getting a sense of the ministerial intent, because such statutory interpretation is much needed when we are looking at interpreting, or the judiciary's ability to interpret such an important legislation. So I do want to check with the minister in terms of, does it actually mean that something like a wealth tax would actually be reasonable under F Roman numeral 1? Lastly, we're looking at, in terms of the role of courts under J. My question to the minister is around this idea of existing legislation. Now, we will see this sort of happening a little bit, and this was mentioned in the previous part as well. But when we're looking at the evaluation, and this might come up again when we're talking about the board, that there is a retrospective element to it, because existing legislation will also be reviewed as a part of this. So I want to check then with the minister on kind of, in that case, how long would it take for the board to actually go through and look at some of reviewing this? Because, there are, I'm sure the minister is aware of, a lot of, not just existing legislation, both primary and also secondary. So is there a particular timeline that you are looking at in terms of existing legislation? My third question is kind of drawing on from both taking of properties, taxes, fees, and levies, and also in terms of good lawmaking. The minister before talked about the fact that, if there is a taking of a property, and, if the person taking of that property needs to be reimbursed, that it is everyone's objective to actually do that. And if we're looking at the fact that we're looking retrospectively under good lawmaking, so something like the Public Works Act surely is encompassed by this, in which case any taking of the private property of Hapu and Iwi and Māori would naturally be reimbursed as a part of this by everybody, i.e. the Crown. So would that actually then mean that we're going to be retrospectively also be looking at a lot of the the reimbursement of all of the land that Public Works Act had to take, maybe for good justification. So I wanted to, check on a few of that scenario, and that's my final question for the minister.
Madam Chair.
Cameron Luxon.
Thank you, Madam Chair. Yes, Dr. Lawrence Yunnan just outlined at the beginning of that input that we have covered subpart 1 quite substantially this morning, Madam Chair, and I'm sure you have been paying very good attention to the committee stage of this bill. I was hoping, considering the Minister's well-traversed explanations to and answers to questions put by this committee this morning, we could move on to subpart 2, as after all there are 7 subparts in this part of the legislation. And this is the subpart 2 is regarding the reviews of government bills in section 9 and government amendments in section 11. They both are very similar subparts. I would just like to hear the Minister explain how he sees the public, or how the public should be able to interact with that. What methods are ministers who are putting up amendments or bills are required in this legislation to put forward so that New Zealanders can see how their property and their rights are being regulated? Will that include a minister actually speaking to such a thing as a statement, or will it just be written? And consistency, accountability statements, how will the public be able to interact with that? Thank you.
Madam Chair.
The Honourable Dr. Duncan.
Thank you, Madam Chair. And I thank the Minister for his, addressing the questions that are put to him. Would like to talk about Clause 8, Subclause 8D, which hasn't yet been addressed. And this was one that the committee amended, but I'm not, to be perfectly honest, not an amendment which I was supportive of, because the bill as it now is before the House talks about the importance of maintaining consistency with Section 22A of the Constitution Act 1986, Parliamentary Control of Taxation, whereas previously it talked about parliamentary control of public finance. And it strikes me, if you're going to have a regulatory standards bill, that peeling it back to not talk about public spending, but only talking about public collection of money, that it doesn't make a lot of sense. So I was actually really perplexed as to, because this was not a suggestion that came, this was a suggestion, if I remember rightly, that came from officials, and I'm simply not clear as to why, if you're going to regulate or have a regulatory standard, why you wouldn't have a standard relating to public finances generally and only to taxation. And if we're going to talk about taxation, then the principles of good taxation, there's a good argument that they should be expressed as well. So first of all, that's my amendment paper 8:30 and 28 AM, and then the next amendment paper actually skips, I don't know what I was doing in the next hour, 9:45:06 AM, which is actually about just having a framing of what good tax is, because I think it's important to identify that tax isn't just about getting money, it's also about correct behaviours, so that you don't, and there's that whole idea that you don't want to have a tax system which perversely changes behaviours, but you can have a tax system which encourages good behaviour, whether it's an environmental tax or whether it's the way in which our income tax system works, or indeed the way in which a capital gains tax system might work. So my amendment paper of 9:45:06 talks about the purposes of a tax system are to raise revenue, to finance government expenditure, and to correct behaviour or market failures. I mean, so that would be the kind of cigarette excise tax would be a good example of that. There are a number of other suggested amendments, but I'm actually not going to talk to them around the tax framing, because I know the Minister will have looked at them and I'm sure he'll be able to do that. But in terms of taxes and levies, there is a good argument to say that we need, if we're going to talk about that here, we need, and this is my 8:30 AM amendment, a taxes and levies framing that says it's appropriate to have a levy across an industry where it's not appropriate or practicable to differentiate across all goods and services. And this addresses the issue where you might have a licensing regime and there's different classes of licenses, there might be different costs of testing, but in practical terms, whilst it's possible, it's not effective or efficient or practical to differentiate. So that's why I would suggest we have a framing in terms of taxes and levies there. And I don't need my full minute for those framings, so I'll let someone else have the next call.
Madam Chair.
Honourable David Seymour.
Thank you, Madam Chair. If I can quickly address Dr Lawrence Sunan's reference to 8C2 and his definition of owner. He appears to want to amend that so that an owner can be an individual, not, for example, a trust or a company. I think sometimes people forget just how many New Zealanders actually use things like trusts and companies to hold their assets. It's actually not just big bad corporations that some people like to bedevil. Actually, it could be a tradie with a limited liability company. It could be the person at the corner dairy. It could be someone in your family who holds property in trust, perhaps to protect themselves in relationship property. So no, the owner should not be limited just to a person. Lawrence Sunan asks, hopefully, would a capital gains tax be allowed under this legislation, or a wealth tax? He says, no, this bill wouldn't stop that if the government wanted to pass a Parliament wanted to pass such a law, the voters, on the other hand, might have something to say about it. He suggested that somehow doing reviews of existing laws was retrospective. It's actually not, because no review would change the law for prior cases. It would, the review might lead to changing the law for future cases, but that is not retrospectivity as most people understand it. And he asked if Public Works Act compensation would be paid to Maori who had land taken under the Public Works Act. Well, actually, the whole point of the Public Works Act is that no matter what your background, you get compensation if your property is taken, so that wouldn't be necessary for Maori or any other person. We had a question from Cameron Luxon, but that was about the next subsection, so I'll just go to Duncan Webb. He asked about the change in the that the Select Committee made to 8D to restrict it to Section 22A, so that it was parliamentary control of public finance rather than taxation. The reason for that is that the intention here was always taxation. It was a drafting error. The full Section 22 of the Constitution Act also refers to government borrowing and spending of public money, and this is about taxation, not the other two things that the government can do with public money. So that restriction's been done deliberately and purposely. We have no intention to change it. Finally, Dr. Duncan Webb asked if we should put the principles of good taxation into the law. He may have forgotten only 2 years ago when his party was in government, they actually passed an entire piece of legislation called the Tax Principles Reporting Act. So it would be strange to now want to put the same thing in this piece of legislation. The government has no intention of doing that. Cameron Luxon asked about subparts 2 and I believe 3, which relate to how these principles are used in relation to consistency accountability statements and how the public can interact with that should the Minister speak to it. As I said, I've said quite a few times now, the purpose of the Act is to support good quality lawmaking, and the main way it does that is by providing these consistency accountability statements to the House when a government bill is introduced. The Minister must either link to a statement published on an internet site or make a statement briefly explaining the government's reasons for inconsistency, which also answers the earlier question from Vanushu Walters about why do we have a Section 5 Bill of Rights equivalent. There are, of course, times when you don't have to have a consistency accountability statement. Those are times such as when the legislation is that listed in Schedule 1. That's derived from Part 1, which we debated last night, so I won't go into the definition of that law. The committee's dealt with that already. However, the question around, well, how will the public and the Parliament and the Minister interact with it? Once the public see the statement published under the authority of the House, then there is ample opportunity for public debate about, well, do we like this law, and are we aware of all of the impacts that it will have on people, liberties, their property rights? Was the law made well? Did they consider all the options? So it's precisely to inform public debate, and I think a lot of people will really welcome that. And also subpart 3 he referred to responsibility to engage in regulatory stewardship. This is something that Lawrence Sunan also got into tangentially. There's a requirement for chief executives to prepare a program of retrospectively, and not in the sense they're going to change the law retrospectively, but going through the stock of existing legislation that chief executive is responsible for under the Public Services Act, and going through and checking each of those pieces of law against consistency accountability statements and reporting on whether changes are required. There's no timeline on that as there was in the bill as introduced. However, I believe that will be a very useful way of applying the principles.
Madam Chair.
Ricardo Menendez-March.
Thank you, Madam Chair. I'm just jumping to Clause 11. I know some of my colleagues may still have questions on some of the previous clauses, and I think this is where this question best applies. The Minister in his previous remarks made commentary around how a lot of these statements would be in relationship to the introduction of bills. Clause 11 talks about government amendments. One of the recent examples we have seen over the term has been that the government often introduces quite major amendments to bills at the Committee of the Whole House stage after the Select Committee period. Some of these amendments actually make substantive changes to bills. And so I wanted to test with the Minister as to whether Clause 11 is the place where that may capture, for example, ministers throwing amendments in between the select committee stage and during the committee of the whole House stage that may actually substantially change the bill or add components to a bill that are quite significant. The reason for this is that because if we keep talking about, as we have referenced previously, around high quality lawmaking, does he think that such amendments would change a bill really substantially? And, for example, we had the medicines bill just recently, which the minister was in charge of. It added a whole new part around medical conferences. And, for example, if I recall during that debate, the minister kind of made an offhand remark around the revenue. He didn't have the sort of like figure on top of his head, and kind of just, we just had a revenue figure thrown at us at the time, and without any substantiation or sort of corroboration of it. And my concern is that, for example, would that have met then the principles of good quality lawmaking, and would the provisions in Clause 11 around government amendments help mitigate any of that? And if not, at which point does the minister believe that provisions of Part 2 of this bill would help create safeguards for government ministers, such as himself, introducing amendments during the committee of the whole House stage without any sort of information to substantiate the benefits or the merits of those very same amendments that would have not been discussed during the select committee stage. I raised the recent example of the medicines bill, but actually throughout this term we have seen quite a few significant amendments making major changes to bills. And I can see my colleagues to my right, I think, yelling some examples. And my reason for that question again is, if Clause 11 isn't where that would create a level of safeguards against ministers substantially making changes to bills at the committee of the whole House stage without select committee scrutiny, where would he ensure that there are protections in place so that ministers cannot bypass these principles by simply just putting a bunch of amendments at the committee of the whole House stage way after it's been introduced and way after the bill has had a select committee scrutiny? Because so otherwise, I can see a really easy bypass for a lot of these tests is for the minister to just add a bunch of amendments later down the line at the committee of the whole House stage without adequate scrutiny, without this test being applied. And
I think
so
the question
I'm really
is well understood, and you've repeated it twice. So, is there anything else you'd like to add?
Well, if the minister doesn't have an explanation, doesn't think the minister... Thank you. There we go.
Madam Chair, if he's that eager, I usually answer, wait for 3 or 4 and then answer them, but I'd invite the Minister to read a bit further down member, yes, I apologise, to section 12, which sets out under section 12(1)(a), (b) and (c) 3 circumstances where a consistency accountability statement is not required, and that is if it is a kind of bill that is exempt from the law generally, that's in Schedule 1, which we've discussed. If it's not reasonably practicable to comply with Section 11 before the scrutiny occurs, so there will be people who will argue whether they've met that criteria, but it still puts an onus on them to meet it. Or if, in the opinion of the Regulatory Standards Minister, the government amendment would not materially change the bill. Now, if he goes a bit further down, the responsible minister must ensure the statements required presented to the House as soon as possible. If they have used the exemption under 12(1)(a) or 12(1)(b), they still have to present it as soon as practicable after the bill is introduced to the House. So they don't actually get out of producing it, they just won't produce it in time, and the law is clearly designed that that should be in very limited circumstances.
Vanushi Walters.
Thank you, Madam Chair. And thank you to the Minister for some of those answers thus far. Before I leave Clause 8 of the bill, I just did want to ask the Minister one question about substantive versus procedural checks, so substantive rights versus procedural rights, and his view on that, and then I'll move on to Clause 9. I note that when the Bill of Rights Act was debated and then agreed, again, there was an active drafting choice not to include a right to property. So Kenneth Keith wrote about this in an article in 2013 as well, where he talked about the difficulties that the US have faced in terms of understanding the scope of the right, but then also balancing that right in terms of their rights space. The lien in the Bill of Rights Act was a procedural set of rights, essentially, and the understanding behind that was that it was for Parliament to decide the scope of substantive rights and how they might play out. And my question to the Minister is whether he believes that constitutional checks such as this should include substantive rights. And I understand that he says that, you know, what this bill is doing is it's looking at how the government's action is impacting people in terms of particular areas. That still does create, in effect, almost a ghost or a shadow property right. And so is it the Minister's view that those substantive rights ought to be part of constitutional checks? Now, the reason I ask that, if his view is yes, then it wouldn't make sense to discriminate against which set of rights could potentially be in that space, and potentially at some stage in the future, in the same way we could see economic, social and cultural rights or environmental considerations also part of an assessment of this sort. Or is it his view that no, that is a realm only for the procedural, as was the view taken by our predecessors when they negotiated and passed the Bill of Rights Act? So that's my first question. Moving to Clause 9, the review of consistency of the bill with the principles. So the language that is used in the bill echoes the language of the Bill of Rights Act. It says if a government bill is introduced into the House of Representatives, then these checks should be made. Now, similarly in the Bill of Rights Act, we have Section 7, where if a bill is introduced to the House, the Attorney-General then has the responsibility to conduct a check against the Bill of Rights Act. An issue that has become clear as we've seen bills travel through the House is sometimes you can have rather substantive amendments to bills as they travel through the House that potentially prima facie do engage the Bill of Rights Act and should have had a second vet if we believe in the idea that the House should, with eyes wide open, assess compliance with the Bill of Rights Act. Now, in a similar way, one could argue that if one was encouraging best practice lawmaking processes, that this set of principles should also have a second review should substantive amendments be made to legislation as it travels through the House. Now, this isn't something that I'm making up. We've seen it come through the House this term of Parliament. When I left the Parliament in the last term, there was a bill travelling through the House relating to consent law and ensuring that consent provisions and how the police charge were consistent in terms of what we believe consent law to be. As I came back into the House of this Parliament, there was a significant substantive amendment that talked about name suppression and how name suppression would be handled in criminal cases. There was no second Bill of Rights Act vet in that case, so the House did not have eyes wide open as it travelled through the House. I believe the gang patches legislation is another example of where there were substantive amendments that the House should have turned its mind to. I have a particular interest in this as I have a members' bill currently in the tin relating to the Bill of Rights Act and ensuring that the House has eyes wide open in relation to amendments made there. So what is the Minister's view? Is that intentional, that it was only at introduction, or is that potentially something that the Minister thinks may be a flaw or something that could be amended in the bill?
Honourable Karen Shaw.
Thank you, Madam Chair. I'm just reflecting on a topic that was raised by the previous Greens member, and that was around amendments tabled in the Committee of the Whole stage, and the conversation around how we have a select committee process where members can talk out a bill and come together with a finalised bill to bring to the House, where they've had opportunities to have discussions around changes that may be made to the bill, and they come to a conclusion that this is the bill we're going to bring to the House. So I'd like to draw the attention, Madam Chair, to the 85 amendments that were tabled on the 4th of November by Honourable Duncan Webb. And I'd just like to ask the Minister Are there any of those amendments that the Minister will be considering today to accept? And in to make this a better process, some of these amendments could have been spoken to in the committee stage, and does the Minister feel that any of those 85 tabled amendments for Part 2 from the 4th of November are actually worth traversing over again, and will the Minister be accepting those amendments?
The Honourable Duncan Webb.
Oh, thank you, Madam Chair. The member needs to learn to count. I think there's 131 amendments actually, and every single one of them would improve this bill. But the Minister, had the member been in the House at the outset, you'd have heard the Minister say that he doesn't propose at the present time to support them, but that's why we're here, so that we can talk about them and persuade the Minister that in fact these are a great idea. One of the ones I'm interested in, and it's another one which came out of the departmental advice, is Clause 8, subclause JA, and it's an outlier because this is the clause that says it is a principle of good regulation of the importance of the responsible agency identifying and developing effective arrangements for implementing the legislation. And the ministers themselves sort of brushed aside some suggestions on the basis that, no, these are all principles of a particular nature, essentially a checklist of when you go through legislation, say, yes, it meets this quality standard. Whereas this here is actually highly operational. And it kind of sits really oddly. So I guess my two amendment papers, and they are clearly alternatives, the two amendment papers suggest either we just do away with it because it's not actually a principle of good legislation, it's a principle of good government or good bureaucracy to make sure that you've got the resources, you've got the people, you've got the education, and you've got all of those procedures in place to implement your legislation effectively. So it's not about the rules, it's about the operation of government. But if you are going to do it, the other way to do it would be to actually explain exactly what you mean, rather than just saying identify and develop effective arrangements for implementing legislation. Not only do that, but also ensure that appropriate resources are devoted to implementing the legislation. So this is my amendment paper filed at 9:20 and 13 a.m. Or ensuring that people affected by the legislation are aware of its import and how to comply with the provisions as required. So that's that educative piece. So I don't think anyone's spoken to this particular subclause of Clause 8, but I'm interested to know, why is it in there? It's an outlier clause talking about how government should operate rather than how it should legislate. And what exactly does it mean? And does it mean that, for example, you've got to have enough money to do the job that you've been asked to do, and that you need to get out and educate and so on and so forth? I guess the other thing I'm going to skip over a couple of amendment papers because I know the Minister's read them and he'll have thought very carefully about them, but there is one thing in terms of costs and benefits, and that's my amendment paper filed at 9:20 and 15 a.m, just making sure that costs, because costs is actually, whilst economists will understand what's meant by cost, most people think it means only fiscal cost. Another way to express that, and this is my suggestion, is replacing costs with detriments, because downside is what we're interested in. And whilst some economists would frame cost, take a detriment and put it into a number, a money number. Another way of accounting is just simply to look at them and balance them in the round, including all downsides. And some of those downsides which are hard to measure are loss of social cohesion or, loss of enjoyment of life and things like that. So I'd be interested in those two things. Why have we got this outlier clause about effective implementation? And then in terms of costs, would it not be better to kind of have a slightly more expansive term so that people coming to this legislation will understand that any downside is a cost, not just monetary or fiscal or other easily measurable downsides?
Francisco Hernandez.
Thank you, Madam Chair. I want to move on to Clause 13, accepting, of course, that my colleague Duncan and others around the House have still have some stuff from previous sections. But I've learned from previous Committee of the Whole House sections that if you don't ask the question you want to ask when you get the time to, you might not get the chance to. So I want to ask a question around the secondary legislation section, particularly the review of consistency of secondary legislation with the principles. So this is sections 13, 1, 1A, 1B, and 2. And I want to ask, first of all, is there a working definition that the minister is using for secondary legislation? And number two, is there like a materiality threshold in which secondary legislation is captured under this? Because, secondary legislation can apply to all sorts of things. It can apply to regulations, can apply to orders in council, can apply to rules, notices, and local authority bylaws. And does the minister anticipate that everything in that bucket will be captured? Because I've just checked the secondary legislation website. I was doing some research earlier while we were looking at the time. And in 2024, 307 pieces of secondary legislation were made and just were uploaded just on the New Zealand legislation website. I know that that doesn't encompass all the secondary legislation that gets developed, including the local authority bylaws, crucially. And I know that in 2025, and there's still two more months left of the year, that 259 pieces of secondary legislation were made. So is the minister's intention with this legislation to capture every single piece of secondary legislation that gets developed and proposed? Or is there like a more materiality threshold? And is there an expectation of adjusting the consistency accountability statement depending on, I guess, the length of the secondary legislation at hand? Is there an expectation that, if there's just a council bylaw, for example, if council bylaws are even captured in this, that regulates, walking your dog in the park, for example, that it'll have a short consistency accountability statement versus a more complex set of, regulation, for example, ETS regulations that, might govern some more fundamental and, wide-reaching things. So just to recap my questions, what is the working definition of secondary legislation? B, is there a materiality threshold in which secondary legislation is captured? And does that include like all local government bylaws, for example? And I know that if we check Schedule 1, that it does refer to local acts, but I don't believe that captures, I think that just captures like when you make a local act in Parliament and then like the one we had with the Auckland Future Fund, that it doesn't actually include local government acts. And my third and final question was around, is there an expectation that the consistency accountability the cases are proportionate to the secondary legislation that's being reviewed?
Madam Chair.
The Honourable David Seymour.
If I could just address these questions. Venushi Walters asked, is this these substantive or procedural rights that are set out and she was arguing that the Bill of Rights has procedural rather than substantive rights, but the Bill of Rights actually does set out a number of what I would regard as quite substantive rights: freedom of expression, association, and so on, and along with procedural rights if you're to be arrested. I think in this case we are setting out rights that a consistency accountability statement should take account of. That, as I've said a number of times now, is the purpose of the Act, to produce those CASs. And so she could argue that it's a procedural right to have a CAS and that the rights within it are substantive, but I also remind her of Section 25, which says that this doesn't create justiciable rights that can be upheld in a court by an individual. So I hope that addresses her question. The answer is both at different times. She also asked, is there a second vet on an amendment introduced by a government bill, as I understand she is attempting to do with the Bill of Rights, so there will be secondary Bill of Rights opinions on amendments to government bills that are introduced later in the lawmaking process. Well, the intention here is that, that certainly there will be a second vet, if you like to call it that. So this bill comports with what she's trying to do with the Bill of Rights, so I hope that she's pleased to hear that. Karen Shore asked, will the Minister accept any of, I think she said 85 amendments. Duncan Webb boasted that there are actually 131, and I think that in itself probably tells you something. But certainly I haven't seen any I'd like to adopt yet, and each one that Dr Webb has raised, I've been able to give a reason why the government doesn't intend to adopt it. So in answer to Karen Shore's question, no, there are no more that we want to adopt, and everyone that's been brought up I've been able to explain why not, and that will continue. It's just a question of how much time people want to spend on it, and I think when someone produces 131 amendments, many of which I've been able to show are quite misguided, people will make their own judgment of that. And then, funnily enough, the next question was Duncan Webb asking about an amendment. He said that he wanted the implementation clause removed because he felt that it was more procedural and to do with resourcing of government departments. No, as I explained in the my previous answer, the Resource Management Act is a very good example of what happens when there's not a clear plan. It doesn't mean the plan has to be resourced at the time. That's a separate funding decision for a government and its budgets, but you have to at least have a plan of how you would implement it. And if we'd done that with the RMA, I suspect New Zealand would be a significantly wealthier place. And then there is the question of, should the word costs be replaced with detriments? I just would refer the member to George Orwell, who said, never use a foreign phrase such as the French-derived detriment when an everyday Saxon equivalent such as costs is available. Much easier to understand, and it saves a few letters, and in a funny way demonstrates a certain amount of class. So we won't be adopting that on the basis of good style and taste, and I highly recommend the essay Politics in the English Language to Dr Webb, so that he doesn't fall down the rabbit hole of using increasingly verbose diction. Francisco Hernandez, I apologise to the member. I really liked his name. He asked if secondary legislation is included and how is it defined. Well, first of all, he referred, I think, to section. I don't have the section number in front of me, but the subsection after that refers to the Legislation Act, and that is indeed where the definition of secondary legislation can be found. It's also useful to see that it's the maker of legislation. That may be a new term to some people. It was to me when I first got involved with this, but the maker can include a council, and so people who are worried about councils making bylaws that violate their rights or are not well made can be assured that that can be counted as secondary legislation. The council will be required to publish a consistency accountability statement when publishing the bylaw, just as you would be required when publishing secondary legislation to do that.
Nancy Lou.
Madam Chair, I move that debate on this question now close.
I'm starting to lean that way. I've been in the chair for 45 minutes and we've made very little progress. We've traversed as I can see, many of the topics more than once. So I'll be looking for very new material, please. Honourable Dr Duncan.
Madam Chair, this is a very important bill, and the Clause 8 is the most substantive clause, and we have taken some time on it as we've gone through it sub-clause by sub-clause, but I think that's entirely appropriate. I want to talk about some amendment papers that I have in, which suggest giving some kind of navigation lights, if you will, some navigation lights identifying what the kind of hierarchy of principles is. And so these amendment papers were lodged at 9:45 a.m. from 9:45:10 through to 9:45:12. Because one of the things is kind of the primacy question, that you've got these principles of good regulation, but they don't necessarily override other principles of good regulation. And whilst Clause 8A says the principles set out in Section 8 do not limit or affect any other principles, my suggestion is that you should actually say in a proposed Clause 8B, none of the principles expressed in Section 8 supersede the principles of the Treaty of Waitangi. So that would essentially be saying the treaty is at least on par. You could say the principles of the Treaty of Waitangi are more important, but at least they do not supersede. And the next proposed amendment paper would actually say, and this is the point made by the Commissioner for the Environment, which would insert a new Clause C, saying nothing expressed in Section 8 confers a right to pollute water or air, or to contaminate soil, or destroy significant biodiversity, including Indigenous biodiversity. So that's, again, essentially, you could just say that environmental sustainability is a preeminent principle. And then the next one is an amendment paper filed at 10:25 a.m. None of the principles expressed in Section 8 supersede New Zealand's duties or commitments under international treaties or agreements. So I do think that there's a lack of signposting. And this Clause 8A is good in as far as it goes, in that it says there are other principles of responsible regulations or guidelines or whatever, but there is no saying, well, and these ones are really important and these ones aren't as important. Because clearly you can consult and then absolutely run roughshod over the principles of the Treaty of Waitangi, and that would not be good regulation. You could run roughshod over international human rights obligations, and that would not be good regulation. So what we don't have is essentially a system to say, well, these things are really important, these things are fundamental, and these things are essentially procedural and operational. Yes, consult, but don't consult and then on the basis of that consultation go and do something which is really bad lawmaking. And go and talk about your takings principle, but don't prioritise your taking principles over fundamental human rights. That's the risk that we have here. So that's why in talking about Clause 8A, moving along, I have proposed not only 8A, but also some additional clauses which would show those hierarchies. Thank you.
Madam Chair.
Honourable David Seymour.
Madam Chair, these matters raised by Dr Duncan Webb have all been traversed extensively. There's been a number of members who have raised the prospect that there should be some form of clause referring to the Treaty of Waitangi as a lawmaking principle. I've explained at length why the government doesn't have an intention to do that. He's certainly correct that 8A allows a consistency accountability statement to be prepared with other criteria if a minister or a department wanted to do that. But the suggestion that there should be a hierarchy of principles is not something the government is willing to accept. In our view, it's equally important that a person's property and liberties are taken account of, and that the law is made properly, and that if a fee or levy is raised, then it's actually used for the purpose that it was advertised for. We don't see a criteria for making a hierarchy amongst those objectives.
Cameron Luxton.
Madam Chair.
Cameron Luxton.
I move that debate on this question now close.
Yep. Point of order, Francisco Hernandez.
Thank you so much, Madam Chair. I just wanted to note that subparts 3, subparts 4, subparts 5, subparts 6, and substantial pieces of this legislation still has not been covered yet.
What is your point of order?
That is my point of order, that to take a closure motion at a time when
Excuse me, who took a closure motion?
To raise a closure motion as the member has
That
proposed.
is entirely the member's prerogative. And it's my choice whether I accept it and put it. I don't need your guidance on that. Thank you. Venushi Walters.
Thank you, Madam Chair. I wanted to speak and ask the Minister a question about Clause 13, so review of consistency of secondary legislation with the principles. And Madam Chair, we had a landslide of submissions, of course, in relation to this bill, in opposition of this bill. One that stood out for me was not in the primary hearings on this. It was actually Geoffrey Palmer who spoke to the Regulations Review Select Committee in public session, and I sat in on part of that session, and he raised the very serious issue of the lack of clarity for the public because of this duplication in roles between the work that would happen that's described in Clause 13 and the functions of the Regulations Review Select Committee, whose job it is also to scrutinise regulatory making powers, but also draft regulation as well, and then regulation once it's made against a set of criteria that are set out in our standing orders. And this is where the rubber hits the road, really, is people being able to or not understanding what's going on, whether something is good legislation, whether something is good regulation or not. So we have a set of cherry-picked principles on the one side, which where a report will be produced or regulators will turn their minds towards those principles as they're making regulations. We have a second set of principles that the Regulations Review Select Committee will be looking at, and these are contained in Standing Order 327, where they pay attention to grounds such as whether secondary legislation is in accordance with general objects and intentions of the enactment under which it's made. So that's whether it's vires or ultra vires outside the power, but also whether it trespasses unduly on personal rights and liberties, and then a number of other criteria as well. So the public could essentially be faced with a situation where you have an opinion from the Regulations Review Select Committee that makes one statement about whether the regulations are lawful within the context of the parameters of Standing Order 327, and a very separate report that comes out as a result of Clause 13. And the two quite possibly could be contradictory or could rub up against each other. So firstly, just wanting the Minister's acknowledgement that yes, that plausibly could occur. If that were to occur, what is the Minister's view about which should prevail, what the public should read into that in terms of the lawfulness of the regulation, or the judiciary as well? Now, Geoffrey Palmer's suggestion here was that this could be fixed by a simple direction that the Regulations Review Select Committee's role was the primary role in this space, as it should be. As a committee of Parliament comprised of parliamentarians. However, I note that again, a drafting choice, the Minister has decided not to include that direction or that clarity within the bill, and the question is really why not?
Madam Chair.
Honourable David Seymour.
Madam Chair, I've done this a number of times now, but it's very helpful to go back to the purpose of the bill which we debated in part one, which says that the purpose of the bill is to improve the accountability of the executive to Parliament. So if the executive has produced secondary legislation, it's accompanied by a consistency accountability statement. The Regs Review Committee might well review that secondary legislation, and of course the consistency accountability statement would aid in them holding the executive accountable because they would have additional information. Parliament, of course, is sovereign, and as a subcommittee of Parliament, the Regs Review Committee might decide to overrule or take account of or ignore the decisions or the opinion in the consistency accountability statement. So this actually assists the Regs Review Committee. It does not create confusion so long as people see the purpose of this Act.
Dan Bidwell.
I move the debate on this question now close.
The only reason I'm not going to take that closure motion is because there is some scope towards the end of part two that hasn't been covered. So I invite members to focus there. The Honourable Duncan.
Thank you, Madam
Duncan.
Chair. I want to move to clause 15. And clause 15 talks about regulatory stewardship and the responsibility of chief executives. And the funny thing about this bill is that a whole lot of what it does is done in the Legislation Act, and that's going to be cut out, and a whole lot of what it does is actually done in the Public Service Act as well. And so you've got this kind of overlapping sense of obligations. And I mean, that's why this bill, why the advice the Minister got was that this bill's not really needed. But one of the interesting things is in clause 15 2b, says that the obligations of regulatory stewardship apply in relation to a chief executive if they're a public service chief executive, and a responsible agency, which is kind of non-departmental, only if it's a public service agency. What this effectively does is carve out legislators who are not public service agencies. And there's actually quite a lot of, you don't necessarily think about it, but there's quite a lot of NGOs, is a funny way to put it, but people like the Law Society, the Plumbers and Gasfitters Association, and various other industry bodies in particular who get to set their own rules. But you've got this delegation to make rules, but the quality standards set out in this bill appear only to apply to public service agency delegates, people who are within that kind of loose circle, sometimes a little bit vague, but can be described as in the public service. So in terms of the obligations of a chief executive to engage in stewardship, that's clause 1A, and to ensure that the responsibility does all these things, the responsible agency does all these things, why is it that the Law Society, which actually has several rules, lawyers and conveyancers, conduct rules, solicitors nominee, mortgage company rules, and various other rules. That's just the example I know best. Why is it that they seem to fall outside of the stewardship obligation? So that's why in my amendment paper 104505 AM I've suggested why not just say a responsible agency, whether it's a public service agency or not, because that would seem to be a sensible thing to do. And the other thing is this, the second amendment paper suggests that we delete subclause 15.3, which says the regulatory standards minister the chief executive is responsible only to the Public Service Commissioner for carrying out the responsibility under subsection 1. Well, firstly, this isn't part of the legally binding clauses, so that means nothing. And the other thing is it's entirely duplicative of the provisions about chief executives in the Public Service Act, which already say chief executives are responsible to the Public Service Commissioner for stewardship obligations. So this is another example where, in fact, it's muddying the waters, because you've got this statement about responsibility in a part of the bill which creates no legal obligations, and it overlaps with an existing statement in the Public Service Act. So my suggestion is that not only is it's duplicative, it's actually dangerous because it confuses what the obligations are by putting it in two places which seem to have two separate obligations.
Dr. Lawrence Sunan.
Thank you, Madam Chair. I want to discuss with the Minister, seek Minister's advice on section that hasn't covered, and we are moving through the parts. I have a few questions on subpart 2 before moving on to subpart 3. In terms of clause 9, now the Minister has very helpfully reminded the House before that the key purpose of this bill is to hold the executive accountable. I wanted to check when it comes to a statement from the responsible minister that briefly explains the government's reasons for any inconsistency, mainly because we're also currently going through the standing orders review, is whether the minister would consider that a debatable motion on what that inconsistency could imply as a way of holding the executive accountable for any inconsistencies, whether that's something that the minister has considered, and that's something that, for example, what is currently being undertaken in terms of standing orders review should also consider. I want to pick up on then in terms of one of the things that was mentioned in terms of section 12 when it comes to what is meant by reasonably practicable. This is furthering on from a response that the minister gave before, whereby the minister said that, if it's reasonably practicable that an amendment, that a government or minister have not had a chance to produce a CAS before an amendment has been released. That sounds like in 12B that is okay, but whether then the minister is considered, well, what does reasonably practicable in this case mean, or how often it is being used? So, for example, we've seen sort of certain conventions, certain rules within our own standing orders, but we have seen that being stretched in terms of the number of urgencies that could be considered, or how we interpret the rules around urgency. So I guess what sort of safeguards would the minister have in terms of, then what's to stop everything from coming through and saying, well, it was not reasonably practicable for us to produce a CAS before we release that announcement or that particular amendment, and whether then, again, combining it with the standing orders review that's currently happening, whether if a minister could not reasonably practicably produce a CAS as a part of a government amendment, because again, I think one of the things that we've heard from a previous speaker, there's a clear difference between what is a government amendment, which is covered by this bill, and what our members' amendment that I think has been addressed in terms of the amendments by the Honourable Dr. Duncan Webb. So again, in those cases, whether there's something for the Standing Orders Committee to be aware of, that if that reasonable practicability test is not met, that it potentially would need to require a debatable motion. So I'm curious to hear that from the minister. And I think how it relates to our standing orders is not something that has currently been touched on. Moving on to subpart 3, I'm looking at clause 16 and 17, and this is all to do with in terms of some of the cycles that has been introduced, and I think we haven't at that stage moved this far into part 1. So, I'm quite happy to continue on moving through the bill. And I think in this case, it talks about 4-year briefings and the state of regulatory management system. And I think 4 years is the fact that there is a review clause in there is really encouraging to see. But I wanted to check the idea of at least, and if the minister wouldn't mind providing some examples or circumstances where, under what circumstances the regulatory standards ministry will require, the regulatory standards minister will require the chief executive of the regulatory standard ministry to potentially give a briefing before, the 4 years up. Is there something that is quite egregious that has happened that will meant that a briefing will need to take place earlier? Finally, in terms of clause 17, when we're looking at that responsible agency, and and there's definitions for responsible agency earlier, but I won't touch on that. For regular reviewing of the legislation, again, is something that the minister has considered on what that period for regular reviewing is. So are we expecting responsible agency to do it annually, quarterly, or it's as simple as it can be flexible. There isn't a fixed term because there is a flexibility that's required depending on the size of that particular responsible agency. So we know that some agencies. Oh, sorry, that's me.
Mr. Chair. Cameron Luxon.
Thank you, Mr. Chair. I'm just going to take the advice from the chair earlier in this committee to move this debate along a bit because we have rehashed a few topics and the minister has been incredibly responsive to those rehashings. I'm thinking specifically would like to know about subpart 5 and how the minister sees section 24 operating. The conferring or impose, the Act does not confer or impose legal rights or obligations. Just speaking about why the minister thinks that is a clause that needs to be included in this bill. And also the fact that the Act, it says here, the Act does not regulate reasons and how that interacts with statements that ministers need to publish or give to the public about the reason or not for regulations in regards to a regulatory statement enacting in this bill from earlier parts which we have traversed. Also subpart 6 with guidance. The regulatory standards minister and the Attorney General may jointly issue guidance that sets out recommended best practice. The Minister, you have touched on this earlier, but I think it would assist the committee if we could just have an expansion on what that would look like going forward. Thank you, Mr. Chair.
Venushi Walters.
Thank you, Mr. Chair. I actually just had a brief follow-up question for the Minister about Clause 13, which he answered my previous question in relation to this clause, but I had a follow-up in terms of the role of the Regulations Review Select Committee and their work and their interaction with the statements that will be produced under Clause 13. So as the Minister will know, the committee receive complaints from time to time, and they have direction in the standing orders in terms of what the grounds of complaint can be. The Minister referred to the fact that the committee could view the statement as part of their consideration when making decisions in regards to complaint. I'm interested to know whether the Minister's view is that that is required or whether it's purely a relevant consideration and the committee has complete discretion as to whether they consider it or not. It is important in my view because much of New Zealanders' lives are governed by regulation as opposed to primary legislation, and it is very, very relevant what the Regs Review Committee determines because, as we know, there is a power of disallowance. The House has done it before, and it can have quite far-reaching implications when the House decides to disallow a regulation. So, at present, we have 3272A to I of the standing orders, which set out the grounds that the committee considers, and the committee receives advice and legal advice in terms of determining whether those grounds have been made out. If I were a complainant to the committee, I would want to know whether the committee were required to turn their minds to the substantive shadow rights that are included, or again, whether that is for the committee to determine.
Mr. Chair.
The Honourable Minister.
I'd like to address the last four contributions. I'll start with Venushi Walters and also Lawrence Hsu, both of whom asked very similar questions. Lawrence Hunan asked, will we require debate in the House on whether a consistency assessment statement is appropriate or whether not presenting one due to it being impracticable is appropriate. The answer to that is no. This bill does not interfere in the workings of the House. The House is sovereign. It makes its own rules. No legislation can tell the House what to do, including this legislation, which, as I've now said quite a number of times, is designed to improve accountability of the executive to the House and therefore not to tell the House what to do. Similarly, the procedures of the Regs Review Committee, that's not something that this legislation can change. So no, they would not be required to consider a consistency accountability statement unless, of course, the Standing Orders Committee decided to make that a requirement for them under standing orders, which could happen, but not under this bill. And indeed, the consistency accountability statements will still be very helpful, I would think. Duncan Webb asked about why this requirement to review legislation only applies to public service agencies. That's because they are the stewards of the vast amount of the legislation. It's true there's a lot of other people that make rules, from the Law Society to the Hora Hora Rugby Club. However, this is focused on the executive reviewing its stock of legislation. It might also interest the Minister to see that it's a maker, as I've previously mentioned. He mentioned that is required to produce consistency accountability statements at the beginning of the process, and the Law Society that he referred to is indeed a maker under the Legislation Act and therefore would be in scope for new rules.
Just before I go on now, I have been watching this debate for the last hour, well aware of the rulings and the warnings of the previous chair. There's a lot of material has been covered. Standing and asking a question for 5 minutes and asking the same question many times is getting a little bit repetitive. What I'd ask for members now is some genuine new material which is identified at the start of the question as being an area that hasn't been previously covered, and that will be a consideration from any closure motions which are coming from my right. The Honourable Dr.
Guidance, Mr. Chair, I want to talk about Clause 16, which hasn't been talked about yet, and I want to talk about the cycle of briefings, because and a number of other things. Clause 16 talks about 4-yearly briefings, and this is the Chief Executive of the Regulatory Standards Ministry essentially must take an overview of the regulatory system and provide a briefing to the Regulatory Standards Minister on how we're doing every 4 years. My amendment paper of 104507 AM actually just makes a pretty simple suggestion, and that is that this be a 3-yearly cycle. And the reason for that is you're out of kilter with the electoral cycle. And whilst I don't think it probably is a briefing that you want to have to the incoming minister, to have it every 4 years means every so often you'd be having it in an election year as well. And to make it, and whilst we've got a 4-year term bill before the House, which you might mean we look at all kinds of cycles, the fact here is that this would create a degree of awkwardness, because it is a briefing to the minister. It's not just like the long-term insight stuff, which is more something for the record. So that's my first point. And the second is this, that my other amendment paper, 104508 AM, suggests that the minister should respond. Because if this is about executive accountability, then there's a really good argument to say the minister should get the chief executive's briefing, which no doubt will say we need to do better here, there and over there, but we're doing okay over there, and say, I accept this or I don't accept that. And my suggestion in the amendment paper is that that such a response should do things like provide a work plan in respect of addressing those shortcomings. So that's in respect of Clause 16, which hasn't been talked about. The other clause I'd like briefly to talk about is Clause 17. And one of the things about Clause 17 is it's actually not particularly clear. And so I think that the title of the clause itself should probably be addressed. And it should be that the responsible agency must regularly review legislation and report on progress. And this is one of the ones where it's a soft obligation. And even though we'll get to the clause that says this part of the Act isn't legally binding, but it doesn't give any time frames. And in my experience, when there's no time frame for an obligation, public service agencies put it at the bottom of the jobs list. And so one of my amendment papers is that this should probably be, once it's amendment paper file 1045 and 11 AM says that it should be on a 6-yearly cycle. Now, to be perfectly honest, I'm pretty agnostic as to what the cycle should be. 6 years is every 2 election cycles. But what it would be saying is, look, you should do this. This isn't just at some stage in the imaginary future. There's actually an obligation to do it. And then they should be reporting on it. So my other amendment paper at 11:01 AM adds a clause there which says the responsible agency must provide a report stating the outcomes of the review and any actions or proposed actions as a result of the review. So it's because at the moment these are all kind of aspirational things, and when you've got a busy executive and department, then we see those things fall off the edge. So there's a number of, I've whipped through them, all new material, and I hope the Minister will respond to those.
Mr Chair.
Honourable Minister.
Yes, I can very quickly respond to those. I mentioned earlier that the Government has no intention of adopting any of the 131 amendments that Dr Webb has tabled, apparently as late as 1 in the morning. However, to address these latest ones, amending Clause 16 to have a 3-yearly cycle of reporting in order not to interfere with an electoral cycle. 2 things about that. We don't actually have a 3-year electoral cycle legally. We have a requirement to have an election within 3 years and 3 months of the last one, but at some times in our history we've actually broken that cycle, and we may well do again, or we may move to a 4-year cycle, although that's not currently the law. The reason it's 4 years is precisely so that there is flexibility within the 4-year cycle not to have the reporting or the briefing coincide with the election if that's what the government of the day wants. So his amendment might actually defeat the very purpose that he is trying to achieve, so we certainly won't be adopting that. He then asked if the Minister should be compelled to respond to the briefing. That's a very interesting constitutional idea, because it effectively means that an unelected person can force a Minister to publicly respond to their ideas, which is the opposite of how it should work in a democracy, where the elected person has the choice about how they respond or not. He then said that he'd like a 6-yearly cycle for the reviews. That certainly would strengthen the bill and put a lot more impost on departments to review their stock of legislation. However, I note that the same member proposing this has been quite vocal in public about the costs of doing these reviews. I welcome that he now wants to strengthen the bill. However, the government has come to a conclusion that by not setting a time frame, different departments which might have different numbers of legislative responsibilities can set their pace, of course according to the expectations of the government of the day, rather than a hardwired annual amount. As I mentioned earlier, previously we had 10 years, now we don't, so that's actually a matter that I had already addressed.
Mr Chair.
Joseph Mooney.
I move the debate on this question now close.
Dr Lawrence Zunan.
Thank you, Mr Chair. I have a short question, and as I indicated to the Chair before, I am moving on in Part 1. I'm now talking about Subpart 4, Clause 23. And this is around Chief Executive must act independently. I want to check. This is a really interesting, I think, subsection, because it does say in subclause 2, this section applies despite Section 52 of the Public Service Act, because Section 52 of the Public Service Act specifically says that the Chief Executive is responsible to a minister. But subclause 1 says must act independently and is not responsible to a minister, which I think is actually, good to see in terms of the independence of a chief executive. But I want to check with the minister on how that the minister envisaged this part to be enforced, because again, this sort of steps outside of some of the aspects. And yeah, so it's mainly about enforceability. So how then, for example, as the House, if we do see a consistency accountability report, that then are we under the assumption that the chief executive has acted independently, or is that more meaning that we need to kind of dive a bit deeper to ensure that the chief executive was acting independently when releasing a cast?
Dr. Duncan.
Oh, sorry. Oh, thank you, Mr. Chair.
Mr. Chair.
Honourable Minister.
The answer. Well, he's resumed his seat, so I've been called. Thank you. The answer to Lawrence Yunan's question is just below the part that he read out. The Chief Executive must act independently in relation to two purposes. One is making a consistency accountability statement. The other is giving a briefing. Of course, you would assume that the Public Service Act prevails in all other purposes.
Honourable Dr. Duncan Webb.
Mr. Chair, I want to talk about one of the most unusual parts of this legislation. That's clause 24 in subpart 5. And that is the provision that says this Act does not confer a legal right or impose a legal obligation on any person that is enforceable in a court of law. And it is interesting that we were just, the debate over the past 30 or 40 minutes has all been on obligations on chief executives, obligations on departments, but they're in fact not obligations because they're all in this part, and this does not impose a legal obligation. So it's an obligation of some other nature, some sort of moral or administrative obligation, but not a legal obligation. Now, one of the things that came out of Select Committee was, and I think it was the Legislation and Design Advisory Committee, was a concern that the courts would look to this legislation, notwithstanding this section, and see it akin to the New Zealand Bill of Rights Act and give it some force in some way. And there's two ways it could do, the courts might do that. One would be as an interpretive principle to say, well, we're assuming that the legislation we're looking at has been designed with the intention of being consistent with these principles. Now, that is, a little bit problematic, and I'd just be interested in the Minister's comments on that. Is that the intention? Because it's a quite likely outcome. The other one is, and of course, under the New Zealand Bill of Rights Act, the New Zealand courts adopted an overseas practice of granting a remedy of a declaration to say the rights set out in the New Zealand Bill of Rights Act might not be kind of enforceable in and of themselves as against legislation, so they can't strike down legislation, but they can say that legislation infringes on your rights in a way which is in breach of the New Zealand Bill of Rights Act. And there was a concern that a remedy of that nature might be developed of the courts. And of course, you can never quite know how these things will go. That's the thing about the common law, that it kind of develops organically and it's not in some kind of linear fashion. But my amendment paper, because I don't think that's what the Minister suggested, but my amendment paper of 11 o'clock and 7 seconds AM inserts a new subclause 1A in clause 24 and simply says no declarations of inconsistency that with this Act may be made by any court. And that would simply clarify that status. But I'm also interested, so that's that bit. I'm also interested in the Minister's observations as to what all of this stuff means. Is it really just a legislative cabinet guideline? Because a cabinet guideline is a classic example when it's essentially a direction of the Prime Minister to his colleagues as to how they should behave. But if you don't do it, it's political only, and it has no legal force. And we talk about breach of cabinet guidelines and cabinet directions and so on. So why have we got, I think it's really important, why have we got this section which says none of this creates legal obligations? And in fact, the only legal obligations in the entire Act come later in the Act about the powers of our Regulatory Standards Board, which we'll look at later. So I'd be interested in the Minister's comment.
Mr. Chair.
Honourable Minister.
I can answer the question again. There's been a question about does this have any legal rights or impose any legal obligation? And he's right about that, but the second half of the sentence says that is enforceable in a court of law. Indeed, I forgot to address questions by Cameron Luxon earlier about sections 25 and 26. If you follow them through, they are all designed to ensure that the courts do not have their role in New Zealand expanded by this Act. That turns me back to the amendment suggesting that declarations of inconsistency be outlawed. I don't think that that is necessary, and I was thinking about something that Venushi Walters said, that the Bill of Rights was campaigned on through 2 elections. It finally became law in 1990, and it was another 25 years or so before the courts made declarations of the type that Dr. Duncan Webb has referred to. And it may well be that in 25 years' time these ideas will be socialised sufficiently to the point that courts might start making such declarations, and if that leaves us with a country where the executive is more accountable to Parliament, makes more laws more carefully, and is aware of the importance of people's liberties and property rights, and doesn't charge fees for things people don't actually get, that would be no bad thing.
Mr. Chair. Cameron Luxon.
I move that debate on this question now close.
Dr. Lawrence Unan.
Thank you, Mr. Chair. I am moving on in terms of part 1. Part 2, I meant. Part 2, thank you. Part 2, and I'm moving on to subpart 7, which is actually a very important part of this particular section on the Regulatory Standards Board. And we haven't quite covered the Regulatory Standards Board yet. So I know that other people have questions to this, but I think I want to start by asking some questions around section 29 in terms of the functions of the board. And I think in terms of the board, that this is something that that I think requires some attention and just some elucidation from the Minister on the independence of this board in order to provide information. Now, we know that from a secondary legislation perspective, we have the Regulatory Standards Board, and the Minister has already mentioned that. And that is something that is bipartisan. And I think there's also another possibility which was raised by my colleague Francisco Hernandez when it comes to the Regulatory Standards Board, whether the Minister, to start with, I think a broader question, in order to maintain the independence, rather than reporting to the Minister for Regulations, has the Minister then considered, for example, having that as an Office of Parliament and having something like that being incorporated into the Parliament system, much like the Ombudsman and the Auditor General and Controller. So I'm going to start with that very kind of broad question, and then I will have some specific ones on subpart 7.
Mr. Chair. Venushi Walters.
Thank you, Mr. Chair. I have a few questions on different clauses, which I'll go through quite quickly. For clarification, clause 19, so this is new section 17, it says, it refers to the secondary legislation could be of a class specified in a notice issued under this section. So this is just framing up which secondary leg could be reviewed against this set of principles. I imagine that the Minister is referring to regulations that have been made before the Act passes, but are there other classes of legislation that the Minister is referring to? And if so, I was just wanting those specified, but clearly that may not be the case. Clause 20, that sets out the good lawmaking principles, they don't seem to neatly mirror the clause that sets out good lawmaking principles, and in particular, I was thinking about the need to review implementation and issues that had occurred with implementation. Again, it could be that the Minister believes the language encompasses that. I just noticed it wasn't a direct mirror of the good lawmaking principles that the Minister had set out earlier in the legislation. And then I had a question on clause 22. So statements on review of secondary legislation. This is where an agency who has reviewed the secondary legislation is directed to publish that review on an internet site and explain the maker's reasonings for the inconsistency, if there is an inconsistency, but also set out the proposed actions, if any, to remedy that inconsistency. Now, I go back to the Regulations Review Select Committee because I sat on the committee, and I tend to think through practically what is going to happen once this comes out. It feels to me that this would be a nice place for a trigger of interaction between the committee and the publishing agency, as it would be problematic if you had action that was being taken or proposed without Regs Review potentially having its view on consistency with other principles that sit outside the bill. The Minister mentioned the standing orders earlier, and I'm just wondering whether it's the Minister's intention to take proposals to the Standing Orders Select Committee, and of course they're sitting at the moment in terms of ensuring there's clarity about the interaction between this process and the role of Regs Review.
Mr. Chair. Tom Rutherford.
I move the debate on this question now closed.
Fernando Hernandez.
Francisco Hernandez, Mr. Chair.
Francisco Hernandez.
Thank you. Thank you.
I'm
That's
catching
all good.
it from the Minister.
It's all good. Thank you, Mr. Chair. It's catching. It's contagious. It's catching today. My question is based on Section 35 around a final report that the board must give, and just checking my understanding of the answer that the Minister gave earlier when I asked whether, and we do know that the board has powers to make inquiries into secondary legislation, and earlier during the debate I asked the Minister whether the secondary legislation included council bylaws, for example, and I believe that the Minister replied in the affirmative. In the case of the final report relating to an inquiry on secondary legislation that's been created by a local council, who would, in the context of 35(1)D, who's the responsible minister in the case of a local council bylaw, for example? That's my first question that relates to the board and the final report. My other question relates to the board itself, and I note that the details of the board on where the board sits in terms of the Crown fee schedule sits isn't in this legislation. So I'm just asking the Minister whether in terms of the classification of the framework for Crown remuneration, whether the Minister anticipates that the Regulatory Standards Board sits in Group 1, that's Royal Commission, Public Inquiries, Government Inquiries and Minister Inquiries. Group 2, Statutory Tribunals and Authorities. Group 3, Governance Boards, with a Group 3A being General Governance Boards, including TEIs. Group B, Subsidiary Boards of Statutory Entities of Crown Agents, ACs, ICEs, or Group 4 of all other committees and other boards. Under the kind of Crown Governance Fees Framework, which section, which group does the Regulatory Standards Board sit in at the moment? So just to recap my questions, my question was around if there was a local bylaw, which responsible minister would receive the report under 335(1)D? And my other question was, which group does the Regulatory Standards Board sit in terms of the Crown framework for remuneration?
Mr. Chair. Happy to address these questions. First of all, Lawrence Shunan took us to subpart 7, and his question was written down by me, but not very legibly, so it's apologies for that. But it was about the Regulatory Standards Board. I might just go to Venushi Walter's question and come back to that. Clause 19, she asked about what is the class of secondary legislation used under this, reviewed under this law. Basically, new secondary legislation is in, old secondary legislation is out, and both of them can be changed by exception. So the backward-looking reviews do not apply to old secondary legislation unless they're explicitly ruled in, or they're the product of secondary legislation that did have its own consistency accountability statement when it was first introduced. Section 20, she says it doesn't map to the Section 8 very well. I would contest that. It says that Section 8 applies, but two sections are ruled out: consultation and implementation, because if you're reviewing something that's already done, then you can't really review the consultation that was done at the beginning. The implementation, that's already been done, so you're really reviewing the law as it stands today, not as the process that it went through to be made. So I think that actually does line up quite well. Venushi also asked if I intended to take recommendations to the Regulatory Review Committee so that the the bill and the committee could interact. I'm open to doing that, but I think it would be presumptuous to do that before the Parliament actually passed this legislation. But I have presented personally to the committee and said I hope at some future time they will actually interact, because I think there's a lot of scope for that. And then Francisco Hernandez, yes, thank you, I'm getting there. He asked a couple of questions about the Regulatory Standards Board, mainly where does it fit in the fees framework. That's not actually something addressed in this legislation. Obviously it's something the government will have to consider before it appoints the board, but it's not something that's legislated that's up for debate here. And then I think the question that, if I remember Lawrence Yunnan in his question about the Regulatory Standards Board was asking, what is the role of this board? As I've laid out previously, it is to, first of all, carry out inquiries, second of all, to review consistency accountability statements and the quality of those. There's a series of criteria around how it's made, but the point is that it's an independent board, people that have expertise in law and regulatory economics that can consider the quality of consistency accountability statements and carry out other inquiries into regulatory quality from time to time.
Stuart Smith.
I move the debate on this question now close.
Dr. Duncan Webb, but I warned that short, sharp and specific is what is required.
Thank you, Mr. Chair, because I wanted to talk about...
And you.
Yes, it is. Mr. Chair, your tone.
I want to leave you in no doubt.
No, it's about inquiries, because we haven't really talked about this function of the board. And it's interesting because the Act talks about inquiries in Clause 30, which is what I mainly want to talk about, but then it talks about a complaints system. So it's really unusual to have a complaints-driven inquiries system. If you complaints generally drive disputes. Inquiries are generally seeing a problem and going for it. And one of my concerns is that if we've got a complaints-driven inquiries system, then you're going to essentially, it's going to be kind of infected with a dispute's flavour. If we take, for example, and I know this is hotly contested, but it's a really good example, the farrowing crates rules that have just been introduced. That's an example where people will complain. So the people who don't like the new rules, will say this is a bad piece of legislation and it's the result of bad regulatory stewardship. Now, one of the questions is how people affected by it, and there's only about 17 people here, are treated properly, as I understand it. and that's why my amendment paper 11:35:04 a.m. It's 11:35:05 a.m. talks about ensuring natural justice. Because if what's going to happen here is that the landscape is going to change, the regulatory landscape is going to be changed, and the lobby group over there, let's be honest, Greenpeace over there says this is a terrible piece of legislation, then pig farmers over there need to have, and there's the Pork Industry Board, I think, or Pork Industry Association, needs to have a right to be engaged. And that's called natural justice, that no one can be subject to a procedure which will affect their rights unless they've had a right to have their say. So that's why in my amendment paper I suggest that in section 30 it states the board must comply with the principles of natural justice in any inquiry, which is really just saying make sure people affected will be able to be heard. Now, if it was not a complaints-driven process, where you've got Greenpeace complaining about the pork farmers, if it was simply the board going, okay, we think this is an area that needs an investigation, natural justice would not apply in the same way, because it's just an administrative action. But when you've got, because the clause 32, actually, and it's a concern to me that you're inviting people to essentially make attacks on other interest groups by saying this regulation isn't fair or that regulation isn't fair. So I do think the natural justice point's a good one. And, you know, of all the amendment papers, and I know the Minister's taken a view, this is one that warrants being supported because it's a simple procedural tool, and maybe other parties in the House might want to think about it. The Minister's not in charge here. This is a question for the House, and I'd be interested in that support.
Mr. Chair. Lawrence Zunan.
Thank you, Mr. Chair. Following on, so I did mention that I have a few more questions regarding subpart 7. I'm going to keep them concise. When it comes to carrying out inquiries, we've heard from one perspective there can be complaints or members of the public raising it. Can I just check for the Minister's clarification, can then a Minister direct the board to carry out an inquiry? Understanding that, you know, there's the insertion of section 30A, which means that the board must act independently, but I want to check if that is a possibility. And when a board carries out inquiries, are they confined then to, because I think this is the section to discuss this, are they confined then to clause 8, the principles of this bill, or are they also in terms of clause 3, the purpose of this bill? So I want to check if when the board is carrying the inquiry, it can be expanded. I then want to ask the Minister, so, you know, in terms of the function of the board is going to be doing a substantial amount of work in terms of, you know, consistency, accountability, reporting to the committee, before to the House, you know, doing work that is very similar to or has certain degrees of overlap with what agencies and OAG and etc. are already providing. But I want to then check what then is going to be the cost that is going to be, has the Minister considered what is the cost or budget that's going to be allocated to this board for it to be able to carry out all of these functions fully? So that's question number 2. Question number 3, I'm going to move on to clause 30, and that's my last question for this part, for this contribution, which is around this idea of on paper, but then he says on the papers. And so I think the first question is, if the consistent statement must be carried out on papers, do they mean that it has to be in writing? Is that what we're looking at here? Oh, yeah, I'm seeing a nod, great. So how then would it mean for people who potentially, because, you know, one of the core principles is everyone should be treated equal. How then would it be for people who have difficulties putting things down on paper and much prefer give an oral presentation or etc.? Would that then also be acceptable? Or you're looking at, you know, that person's need to put on paper and there'll be other resources available for them to be able to put that in writing. And I think the final, that's question number 3, the final questions, it's very very disconcerting when clause 30 says on the papers with a definite article, and I just want to check when they say the papers, does it mean order papers? Like it must be a very defined paper we're looking at here. So those are my 4 questions.
Mr. Chair. Miles Anderson.
I move that debate on this question now close.
Mr. Chair.
The Honourable Dr. Duncan Webb.
Yeah, I'd like to move on, if I may, to clause 35. Clause 35 relates to, and associated clause 36, relates to the reports of the Regulatory Standards Board. And there's actually a little bit of a mismatch in here, because it says in clause 35.1 the board must give a copy of the final report on an inquiry to the following people, and in there the complainant is included. Now, which actually just shows this kind of disputation problem. Now, I can understand why. If you've made a complaint, you want to know. But then in clause 36, the ministry must publish reports, and then it says they can redact information in clause 36, right? And I can understand that if there's, commercial sensitivity would be the obvious one, but equally you might say, the report might say we spoke to this person who gave some important disclosures and you want to protect their identity, all recognised reasons for disclosure. As soon as you give that report to the complainant, it's in the public domain. And there is no power to redact any information in that report going to the complainant. So if we've got a report, to use my former example, about farrowing crates going to Greenpeace, the first thing that's going to happen is it's going to go up on their website in full, unredacted, right? And there is no power to redact there, and you can't overlay that. You can't, as a bureaucrat, you can't say, here's the report, but it's confidential. And so my amendment proposes that in 35 you insert a subclause 4, which basically is a mirror of 36.2, saying you can redact on OIA grounds the copy of the report that goes to the complainant, so that you're protecting the identities of people, you're protecting commercially sensitive information, and so on and so forth. It's actually a relatively important point, and there's no politics in this at all, right? But it is actually a really good point. The next thing I wanted to talk about is the membership of the board, and we did talk about this quite a lot. That's clause 37. And we can talk about the number of members on the board, because between 5 and 7 is quite low, because if you have 5 and a couple are sick, you get into all kinds of trouble. But the real thing I want to talk about is the qualifications of the members. And nowhere in the legislation does it talk about the kinds of people that should be appointed. Now, if you look at legislative quality, I would have thought that it was a good idea to say that you want people who are qualified or have experience in making good legislation. The kind of people, not in this House obviously, and not the Minister, but the kind of people who are on the Legislation, Design and Advisory Committee would be a good example. My concern, and I'll be quite upfront with the Minister, my concern is that what we'll get is a bunch of economists. And whilst some economic expertise might be appropriate, what we wouldn't want to see is a kind of law and economics approach taken to good regulatory stewardship. I'm not saying it's not a useful tool, but it's not a test. It's not the sole test of what good regulatory stewardship is. Now, whilst obviously there's been a change here, and I agree that it's a better change, that it's not a direct appointment by the Minister, it's by the Governor-General, but the question in terms of who is appointed, at the moment it's 38.5. The Minister may only recommend the appointment of a person who, in the Minister's opinion, has appropriate knowledge, skills and expertise. I would have thought that it would be appropriate to take a more... The Human Rights Act says the Chief Human Rights Commissioner must be legally qualified and must have these other attributes. Why have we not taken that approach here to say we need people who have expertise in legislative quality, expertise in the law, and a range of other expertise, which we could then debate in this House? I'd be interested in the Minister.
Mr Chair.
The Honourable Minister.
First of all, in response to Duncan Webb's questions about the nature of inquiries, his amendment that would add natural justice to an inquiry, I direct him to section 34B, which says that they can actually use the principles but also evaluate who is likely to have benefited and consider whether legislation has produced benefits, all based on events that have occurred. So I think that opens them to be able to hear from other people, but they needn't necessarily be holding a kind of quasi-court case. Their job is to report against the principles and see if the law is performing against those principles, not according to somebody's opinion, but according to the principles in law. He also raised the question of whether the reports of the Regulatory Standards Board given to the complainant should be redacted in the same way as the ones that are published. That is an interesting point. However, I think sometimes we just have to trust that most people most of the time know what they're doing and are sensible. If you are the Regulatory Standards Board and you expect that a person is going to leak or publish a report as the Minister has suggested, then you needn't include private information in that report. Sometimes we don't need to legislate everything, we can just use common sense. And I'd reply in the same manner to his suggestion that we should legislate the qualifications of a person on the Regulatory Standards Board. I was pleased to see that he values the knowledge and expertise of economists. A lot of socialists prefer to shoot them, as David Longy once quipped. So that's a progress. However, I also say that the members actually living proof that we should not take august qualifications as proof of competence. So we'd rather appoint people, who are capable of doing the job as the legislation sets out than specify what those qualifications should be.
Dan Bidwar.
I move the debate on this question now close.
The question is the debate on this question now close. All those in favour say aye. Aye. The contrary, no. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand. Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
6 votes opposed.
The ayes are 68, the noes are 55. The question is agreed. The question is that the Minister's amendment to Part 2 set out on AP number 427 be agreed to. All those in favour say aye. The contrary, no. The noes have it.
Ayes have it. Ayes have it. Party vote.
Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
I'll repeat that, please.
8 votes in favour.
Te Pāti Māori.
6 votes opposed.
The ayes are 68, the noes are 55. The question is agreed. The question is that Honourable Dr Duncan Webb's tabled amendment replacing Clause 8 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Marama Davidson's tabled amendment replacing clause 8 be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in support.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
Decided to make some changes.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Marama Davidson's tabled amendment to clause 8, inserting new paragraph AA, is required to require an overriding principle of health of the environment be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in support.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Marama Davidson's tabled amendment to clause 8, inserting new paragraph AA to require all legislation to be assessed for consistency with treaty principles be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in support.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 8 replacing A be agreed to. All those in favour say aye. Aye. The contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in support.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Tamara Paul's tabled amendment to clause 8, amending A be agreed to. All those in favour say aye. Aye. To the contrary, no. Noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in support.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to clause 8 replacing A to 1 be agreed to. Sorry, A to L be agreed to. All those in favour say aye. Aye. The contrary, no. Noes have it. Please conduct a party vote.
New Zealand National.
Votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 8A, inserting new subparagraph 6, be agreed to. All those in favour say aye. Aye. To the contrary, no. Aye. The noes have it. Please conduct a party vote.
New Zealand National.
Whātakau mā iwa a whakakaori.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. We'll just change chairs.
Thank you. Then I'll know where I'm up to. Sorry, guys.
Okay.
Right, so the question is that Honourable Dr Duncan Webb's tabled amendment to clause 8A, inserting new subparagraph V11 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. Party vote is being called for, please, Clerk.
New Zealand National.
49 favours against.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima he whakaae.
Act New Zealand. New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. Honourable Dr Duncan Webb's tabled amendment to clause 8A, inserting new subparagraph V111, is ruled out of order as being the same in substance as an existing provision of the bill. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 8A, inserting new subparagraph 1X, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakaae.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 8, replacing paragraph B, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima ngā pōti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8B, replacing the words after diminish, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Party vote has been called for, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima ngā pōti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8, deleting paragraph C, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Party votes being called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima ngā pōti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. Chloe Swarbrick's tabled amendment to Clause 8, deleting paragraph C, is ruled out of order as being the same in substance as a previous amendment. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8, replacing paragraph C, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is being called for, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima ngā pōti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8C, replacing property with justly acquired property, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima ngā pōti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Francisco Hernandez's tabled amendment to Clause 8, inserting new paragraph CB, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Carl.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima ngā pōti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
6 votes in favour.
ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8 deleting paragraph D be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8 replacing paragraph D be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8 inserting new paragraph DA be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8 inserting new paragraph DB be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8 replacing paragraph E be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8 amending paragraph E be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 8F inserting new paragraph 3 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima na poti whakaae.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Party Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. Honourable Dr Duncan Webb's tabled amendment to clause 8F inserting new subparagraph 1B is ruled out of order as not being in the correct form of legislation. Question is that Honourable Dr Duncan Webb's tabled amendment to clause 8 deleting paragraph G be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote is called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima na poti whakaae.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Party Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 8 replacing paragraph G be agreed to. All those in favour say aye. Aye. To the contrary, no.
No.
The noes have it. Party vote has been called for, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima na poti whakaae.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Party Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 8 replacing paragraph G and inserting new subparagraphs 1 to 4 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote is called for, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima na poti whakaae.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Party Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 8 deleting paragraph H be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote. Party vote is called for, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima na poti whakaae.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Party Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 8 replacing paragraph H be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima na poti whakaae.
At New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8, amending paragraph 1, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa New Zealand.
Te kau marima nā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8, inserting new paragraph IA, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa New Zealand.
Te kau marima nā poti whakaai.
At New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Dr Duncan Webb's tabled amendment to Clause HJ, replacing paragraph I, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote has been called for, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa New Zealand.
Te kau marima nā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8J, replacing subparagraph 4, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa New Zealand.
Te kau marima nā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8, deleting paragraph JA, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa New Zealand.
Te kau marima nā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8, replacing paragraph JA, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote.
Party vote has been called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima ngā poti whakaai.
At New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8, replacing paragraph K, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote is called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8, replacing paragraph K and inserting new subparagraphs 1 to 4 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8, amending paragraph K, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima ngā poti whakaai.
At New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8, inserting new paragraph M, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima ngā poti whakaai.
At New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 8, inserting new paragraph M, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima ngā poti whakaai.
At New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are... The ayes are 55, the noes are 68. The question is not agreed.
Okay.
Question is that Honourable Dr Duncan Webb's tabled amendment to Clause 8, inserting new paragraph N, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote is called for, please, Clark.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Chloe Swarbrick's tabled amendment replacing Clause 8A be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote. Party vote is called, please, Clark.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new Clause 8B be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new Clause 8C be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote is called, please, Clark.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti whakaai.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new Clause 8D be agreed to. All those in favour say aye. Aye. Contrary, no. No. The noes have it. Ayes have it. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti e whakaai ana.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 9 be agreed to. All those in favour say aye. Aye. Contrary, no. No. The noes have it. Ayes have it. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti whakaai.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 9, inserting new paragraph C, be agreed to. All those in favour say aye. Aye. Contrary, no. No. The noes have it. Ayes have it. Party vote is called for, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti whakaai.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 13.1 be agreed to. All those in favour say aye. Aye. Contrary, no. The noes have it. Ayes have it. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono e whakaai ana.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment deleting clause 15 be agreed to. All those in favour say aye. Aye. Contrary, no. No. The noes have it. Ayes have it. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti whakaai.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 15.2, replacing paragraph B, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes whakaai.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 15, deleting subclause 3, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote is called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakaai.
Act New
11
Zealand.
votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti e whakaai ana.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment replacing clause 16 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakaai.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
Whakaai ana ngā poti e ono. So, 6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 16, inserting new subclause 4, be agreed to. All those in favour say aye. Aye. To contrary, no. No. The noes have it. Ayes have it. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti e whakaai ana.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment replacing the title of Clause 17 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono whakaana.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 17, inserting new paragraph AA, be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Ayes have it. Party vote, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 17, inserting new paragraph C, be agreed to. All those in favour say aye. Aye. The contrary, no. No. The noes have it. Ayes have it. Party vote call, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
Yep, you E ono ngā pōti e whakaai ana.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 17, inserting new paragraph D, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti e whakaai ana.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 19.1, deleting paragraph A, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote is called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. Question is that Honourable Dr Duncan Webb's tabled amendment to Clause 19, inserting new subclause 6, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 20, replacing paragraph A, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kao marima na poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 20B, amending subparagraph 3, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whaka-ai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to the title of Clause 23 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whaka-ai.
Act New Zealand. New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. Question is that Honourable Dr Duncan Webb's tabled amendment to Clause 23, amending subclause 1, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote is called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whaka-ai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 24, inserting new subclause 1A, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whaka-ai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 24, inserting new subclause 1B, be agreed to. All those in favour say aye. Aye. Contrary, no. No. The noes have it. Ayes have it. Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whaka-ai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment deleting Clause 26 be agreed to. All those in favour say aye. Aye. Contrary, no. No. The noes have it. Ayes have it. Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whaka-ai.
Act New Zealand. New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 27, amending subclause 1, be agreed to. All those in favour say aye. Aye. Contrary, no. No. The noes have it. Ayes have it. Party vote called, please.
New Zealand National. New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whaka-ai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 27(1), deleting paragraph C, be agreed to. All those in favour say aye.
Aye.
Contrary, no.
No.
The noes have it.
Ayes have it. Party vote.
Party vote's been called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 28 be agreed to. All those in favour say aye.
Aye.
To the contrary, no.
No.
The noes have it.
Ayes have it.
Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. Honourable Dr Duncan Webb's tabled amendment to clause 29(1), inserting new paragraph AA, is ruled out of order as merely being an attempt to criticise the bill. Honourable Dr Duncan Webb's tabled amendment to clause 29(1), inserting new paragraph AB, is ruled out of order as merely being an attempt to criticise the bill. The question is that Francisco Hernandez's tabled amendment to clause 29(1), deleting paragraphs A and B, be agreed to. All those in favour say aye. Aye. Contrary, no. Noes have it. Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 29(1), deleting paragraph C, be agreed to. All those in favour say aye.
Aye.
Contrary, no.
No.
Noes have it.
Ayes have it.
Party vote called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
Act New
11
Zealand.
opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment replacing clause 30 be agreed to. All those in favour say aye.
Aye.
Contrary, no.
No.
Noes have it.
Ayes have it.
Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment deleting clause 31 be agreed to. All those in favour say aye.
Aye.
Contrary, no. Noes have it.
Ayes have it. Party vote.
Party vote called.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. Question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 32 replacing complaints with suggestions be agreed to. All those in favour say aye.
Aye.
Contrary, no. No. Noes have it.
Ayes have it. Party vote.
Party vote called for, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes. Favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Francisco Hernandez's amendment to Part 2 set out on AP number 429 be agreed to. All those in favour say aye. Aye. Contrary, no.
No.
Noes have it. Party vote has been called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 32, inserting new subclause 2, be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it.
Ayes have it. Party vote.
Party vote called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new clause 32A be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
Ayes are 55, the noes are 68. The question's not agreed. Honourable Dr Duncan Webb's tabled amendment to Clause 33(1), replacing secondary legislation with legislation, is ruled out of order as not being in the correct form of legislation. Question is that Honourable Dr Duncan Webb's tabled amendment to Clause 33, amending subclause 2, be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 33, inserting new subclause 3, be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed.
Thank you, Madam Chair. Appreciate your patience.
The question is, it's okay. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new clause 33A be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it.
Ayes have it.
Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumārima Ngā Pōti Whakaae.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes.
The ayes are 55, the noes are 68, the question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 34, amending paragraph A, be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumārima Ngā Pōti Whakaae.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti whakai.
The ayes are 55, the noes are 68, the question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 35(1), inserting new paragraph E, be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumārima Ngā Pōti Whakaae.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68, the question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 35, inserting new subclause 3, be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Ayes have it. Party vote is called, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumārima Ngā Pōti Whakaae.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
In favour.
The ayes are 55, the noes are 68, the question's not agreed. The question is that Francisco Hernandez's tabled amendment to clause 35, inserting new subclause 3, be agreed to. All those in favour say aye. Aye. Contrary, no.
No.
Noes have it.
Ayes have it. Party vote.
Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumārima Ngā Pōti Whakaae.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68, the question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 35, inserting new subclause 4, be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Ayes have it. Party vote called.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumārima Ngā Pōti Whakaae.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68, the question's not agreed. Honourable Dr Duncan Webb's tabled amendment inserting new clause 36A is ruled out of order as not being in the correct form of legislation. The question is that Honourable Dr Duncan Webb's tabled amendment replacing clause 37 be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Ayes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumārima Ngā Pōti Whakaae.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 37 inserting new subclause 1 be agreed to. All those in favour say aye. Aye. Contrary no. Noes have it. Party vote called, please.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumarima na poti whakaae.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Francisco Hernandez's tabled amendment to clause 37 inserting new subclause 1 be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Party vote called, please.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumarima na poti whakaae.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Francisco Hernandez's amendment to Part 2 set out on AP number 430 be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Party vote called, please.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumarima na poti whakaae.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 38 inserting new subclause 6 be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Ayes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumarima na poti whakaae.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 39(1 inserting new paragraph C be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Party vote called, please.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumarima na poti whakaae.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 39(1 inserting new paragraph D be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Party vote called, please.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te Kaumarima na poti whakaae.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 39 inserting new subclause 4 be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Party vote called.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima na poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new clause 39A be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Ayes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima na poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Part 2, as amended, stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima na poti whakahe.
Act New Zealand.
11 in favour.
New Zealand First.
8 in favour.
Te Pāti Māori.
What did you say?
Right, so 6 opposed. Just checking. Sorry, Madam Chair.
Paste check. The ayes are 68, the noes are 55. The question is agreed. Members, the time has come for me to report progress.
Thank you very much, Madam Chair.
Yeah. Yeah, actually we may. I wonder if someone else will be.
Sit in the chair. No,
It's Maureen.
The House is resumed.
Madam Speaker, the committee has considered the Regulatory Standards Bill and reports that it has made progress on the bill. The committee has also further considered the Crimes Countering Foreign Interference Amendment Bill and reports that it has made no progress on the bill. The committee has also considered the Crimes Legislation Stalking and Harassment Amendment Bill and reports that it has made no progress on the bill. The committee has also considered the Offshore Renewable Energy Bill and reports that it has made no progress on the bill. Madam Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion, please say aye. Aye. To the contrary, no. The ayes have it. Those bills are set down for further consideration in committee next sitting day. The House stands adjourned until 2 p.m. today.